I'm sure you've all had an exciting day thus far. My name is Justin Scott. I'm an attorney with the law firm of Babcock, Scott & Babcock. Practice principally construction, litigation, contracts. The rest of my firm also does the same. We're kind of a construction law boutique firm located in downtown Salt Lake City. We're going to talk today about liens and contracts, and we'll take a couple of breaks. I've been in your position before as an attorney. We also have continuing education requirements that we have to sit in on classes like this throughout the year. So I can sympathize with you. I know what it's like to be in your position to listen to somebody like me drone on and on about a topic. I do hope that you're able to learn something from today's topics about liens and contracts that will help you going forward in your professions. Construction industry right now, as you're aware, over the past several years, there's been a downturn, but over the last couple of years, and currently it's looking up. We're seeing that with our clients and throughout the construction industry that things are going pretty well right now. So I think you guys, there's opportunities out there for you. It's competitive. It always will be competitive, but it's a lot better off than it was several years ago. So that's a positive. During the course of this presentation, if you can't hear me or whatever, let me know. This is a big group. If you have any questions, just raise your hand. I'd be happy to try and answer any questions as we go along. If you don't understand the topic or you need a clarifying information on something I'm talking about, just ask me. This is meant to be an interactive presentation, and I encourage participation and questions. I can't guarantee you that I'll have a satisfactory answer for you. I'll do my best. I don't know everything as it relates to the law, and even the things that I do know, sometimes the law is murky. Sometimes it's not black and white. Sometimes it's gray, and the answer sometimes depends on specific facts and circumstances. But I'll do the best I can to give you advice that will be helpful to you. So today, I think we're first going to start off talking about mechanics liens. Let me make sure. Okay, yeah, we're going to talk about mechanics liens first. And mechanics liens, as you're aware, very important in your field, because what they do is they provide you security for work that you've performed to improve a piece of property. And in case you don't get paid by a general or a sub or whatever, you have recourse against the owner of the property to get paid. And that's very important, because sometimes people that you contract with, and we'll talk about this later, but sometimes they don't have the money to pay you. Something happens where they default, and you're left holding the bag, performing a bunch of work and being out money. Well, mechanics lien is one avenue that you can go to get paid, hopefully. And you typically, property that you work on is worth money, and typically, if you try and foreclose on it, there's a good chance that you'll get paid by the owner. But anyway, they're very important. We're going to talk about why they're important. They're also somewhat technical. There's lots of deadlines that you have to comply with in order to preserve your lien rights. If you don't comply with some of these technical deadlines, then you can lose out on your lien rights, and then you're left only with a breach of contract action against the contractor who you have your contract with. So we're going to talk today about some of these deadlines and what you need to do in order to perfect your lien rights. So in case you don't get paid, you can file a lien on the property and hopefully get paid by the owner. Before we start, I just have a few slides, some funny construction projects where disasters happen. As you're aware, not all construction projects go perfectly. There's mistakes made sometimes. We do our best to not have these mistakes, but they do happen. And these are just some fun slides of construction mishaps around the world. Although some of them I think are probably just works of art, and I don't see how this could happen, but they're fun nonetheless. Some of them are probably legitimate, especially where you see maybe some third world country construction. You can see where that could happen. guess you do the best you can. If you have a situation like this, you know. Wow, that's a big crane. That's solid footings, right, and foundations right there. All right, so we're going to talk about mechanics liens first. What are they? Why are they important? How do you preserve your lien rights? And how do you claim a lien? We'll talk a little bit about the Utah Lien Recovery Fund as well. And then later on, after a break, we'll talk about contracts. We'll talk about reading, negotiating, and understanding contracts. We'll go through and talk about some of the provisions that you may want to include in your contracts and provisions that you will want to look for in contracts that people give you so that you're aware of risks of the contracts that you're signing. Okay, liens. So what's a mechanics lien? Well, the legal definition is an involuntary encumbrance against title to real property. It's a statutory device. So laws differ among states. So if you're doing work in multiple states, you're going to want to become familiar with the lien laws of each state because they're not all the same. There's differences between states. There's differences in the lien laws in Utah versus Wyoming. So, you know, I assume you're going to be doing most of your work in Utah, but if you're doing work outside of Utah, you're going to want to check the lien laws there and make sure you do what you need to do in order to perfect your liens. For sure, if you're just doing work in Utah, make sure you're familiar with the lien laws in Utah. They're in Utah Code, annotated section 38A. That's where you find them. And it's probably they're probably 25 pages long, and you know, you should read it and become familiar with it. How does a mechanics lien work? What does a mechanics lien give the title holder, lien holder? It gives that person the ability to force the property in foreclosure. So if you have perfected your lien rights and gone through all the motions, you haven't been paid yet, you can actually file a lawsuit and foreclose on the property that you have the lien filed on. Now, you take subject to preceding interest. So say you have a lien on a property, but there's other liens on the property, like a bank has a trust deed, then you take subject to their interest first. So a lot of times, while you may have a lien on a piece of property, a bank usually is going to be in front of you, and so if you foreclose on the property, any proceeds will first go to satisfy the bank what they're owed, and then you get whatever is left over, if anything. So that's one consideration before foreclosing on a lien. You want to see what position you are in. If there are people in front of you, like banks or other financing companies that have filed before you. Now, contractors, their liens are all on equal footing. So if you're an excavator and you file before the finished carpenter, that doesn't mean that you have lien priority rights over the finished carpenter. If you're the excavator, you're actually on equal footing, and so that's something to consider.
Where do you find out if there's a lien?
Where do you find out there's a lien on it? You can on the county recorder's website. You can look up the parcel property, input the number, the address, parcel number. It'll pull up an abstract of the property and show any liens that have been filed on there, trust deeds, and so on and so forth. So if the property is in Salt Lake County, you go to the Salt Lake County recorder's website. You put the identifying information in where the property is, and that should pull up an abstract which shows you what's on that property. Okay. Liens, they provide a security interest in the property for the benefit of those who have supplied labor, materials, and equipment to improve the property. It's a significant right. As a result, the legislature has created some rigid requirements that we're going to talk about. So basically, who has the right to file a lien? Basically, anybody who does work to improve a property. Okay, so general contractors, subcontractors, suppliers, laborers, they all have lien rights if they perfect them. If you're improving property, you have lien rights if you go through the requirements of the Utah Code. And that includes also engineers, architects. They also can have lien rights. They're considered pre-construction services, but they deal with the improvement of real property. So liens are just not for people actually doing the physical improvement on the property, but those who are doing drawings and such also can have lien rights on a property. Okay. So when you're on a project, you want to understand where you are on that project, where you fall, okay? And what I mean by that is, you want to know who the owner is. You want to know who the general contractor is. You want to know who the different subcontractors are in a project, whether there's second-tier subcontractors, third-tier subcontractors, or suppliers. You want to know where you fit within a project. Let's talk about the State Construction Notice Program. Has anybody ever heard of that, the SCR? Okay. This is going to be very, very important, or should already be important to you. The SCR, State Construction Project website. Now, do you have to file liens or preliminary notices on a project? You don't have to, but the effect if you don't file a preliminary notice to perfect your lien rights is you will lose out on lien rights later on. And you don't want to do that. This is just a snapshot of the screen of what the State Construction Registry website looks like. You know, some of you already may have accounts on here. If you don't, you want to go to the website, and you can just do a Google search, State Construction Registry website. You're going to want to set up an account, username and password, create an account, so that as you're doing projects, you can log in and start filing your preliminary notices, which preserve your lien rights. There's another snapshot of how it kind of looks. So, this will make sense maybe a little bit later as we get into it. But if you've never done one, after you log in, you'll go to a screen like that. And if you want to file a notice of commencement or look to see if there's a construction loan or file a preliminary notice, there's links in the State Construction Registry that you can click on that will take you to a page and tell you what information you need to fill in order to file a preliminary notice or file a notice of commencement. Okay, so the State Construction Registry liens, they apply to all projects, public and private. Can you lien? So we know that liens apply to private projects at least, right? Do liens apply to public projects? Can you file a lien on a public project? Well, when I say public project, any project that is funded by money coming from the state or a public entity. Can you file a lien against a public project? No, you cannot, but you can file, a bond claim. That's what bonds are for. So if you're working on public projects, you want to make sure that there's a bond on the project because that is your lien for that project. You can only file a mechanics lien on private projects. Applies to commercial and residential. So some of the things that you'll see on the State Construction Registry website that we're going to be talking about as we go along. Notices of commencement, that puts everybody on notice that a project has been started, okay? It tells you where it is, who's performing work on it, who the owner is. Preliminary notices, which is crucial for contractors, not only general contractors, but subcontractors and suppliers. You have to file preliminary notices if you want lien rights. We'll talk about that as we get into it. Notice of pre-construction service, those are types of notices that architects and engineers file on a project as they are performing work. Like drawings and stuff like that. Notices of construction loan, that's what a bank would file to put you on notice that they have an interest in the property and that they are funding it. Notices of construction loan default, if an owner defaults on a loan on a construction project, sometimes the bank will file what's called a notice of construction loan default, and that should tell you as a subcontractor or general contractor, hey, this project's in trouble, I have an owner who's not paying his bills, and that should cause you some concern that you should maybe stop and get a meeting together with whoever your contracting party is. Notices of completion, talk about those a little bit later, but an owner or general contractor can file a notice of completion at the end of a project when it's been completed. That's crucial because a notice of completion can cut down your the time on when you can file a lien. If one's not filed, you get a little bit longer time. We'll talk about that. Okay. So in order to file a lien on a project, a private project, you have to perform construction work that improves property. How does the law define construction work? Well, it basically means labor, service, material, or equipment provided for the purpose and during the process of construction, altering, repairing, and improvement, and includes scheduling, estimating, staking, supervising, managing, materials testing, inspection, observation, and quality control or assurance involved in construction, altering, or repairing and improvement. So basically, construction work, Utah law defines construction work very broadly, okay, and it's meant to do it very broadly because basically, if you're doing anything to improve, physically improve a piece of property, that will be considered construction work for the most part. Even staking, estimating, and stuff like that, that is not real actual physical work that kind of goes towards it, will be considered construction work. Let's talk about some of the SCR requirements for private projects. Okay, so notices of commencement. If some of you have been in construction for a while, you'll remember that these notices of commencement on private projects, okay? They used to be required, okay? If an owner or a general contractor did not file a notice of commencement, then that excused subcontractors from having to file preliminary notices. So what that meant is, if a notice of commencement wasn't filed, subcontractors still had lien rights even if they did not file preliminary notices. Well, the laws were changed a few years ago, so now on private projects, notices of commencement are no longer required, and they're not even available on, there's not even an option to file a notice of commencement on a private project. So it's no longer a triggering mechanism for filing a preliminary notice. So what that essentially means is that if you do work on a project, you now have to file a preliminary notice no matter what, if you want to preserve your lien rights. It used to be that if the owner or general did not file a notice of commencement, you were excused from that. You could still file a lien later on if you didn't get paid. Okay, so preliminary notices, everyone is required to file. It used to be that a general contractor, if his contract was directly with the owner, did not have to file a preliminary notice. Now everybody has to file a preliminary notice that performs work on a project and wants to preserve lien rights, okay? So very important now. The deadline to file a preliminary notice, you have to do it within 20 days after your first work. So if you begin work and you finish it, say you're just on the project for a day and you finish it. If you don't file a preliminary notice within 20 days of performing work, then you lose your lien rights for all of that work and can no longer file. Okay? Yes?
Well, with that broad list you gave, what would define starting work for a general contractor? Would that be that you sent out a surveying crew and somehow you're responsible for that survey? Does that mean your work began the day that you sent him, or when you physically actually went on the job?
That's a great question. If you didn't hear it, is when's your actual first work? I mean, would it include surveying or staking or something like that? My recommendation, if you're a general contractor especially, or any contractor, the moment you sign your contract and start performing any work, even if you haven't performed physical work yet on the project, I would file that preliminary notice as soon as possible. I mean, typically, I think the law will basically say physical work, and that would probably include staking and stuff like that. But I think as a matter of practice, you should basically, when you have that contract signed and you start, ordering materials and stuff like that, just file your preliminary notice. There's no penalty if you file and you haven't actually performed physical work on the property yet. Yeah, that's a good question. So, what happens if you're a general and you don't file within 20 days, or subcontractor, you don't file within 20 days of your first work? Well, you can still file a preliminary notice on day 21, but it's not going to apply to any work that you performed in those previous 20 days, okay? You lose the 20 days that you've already performed work, lien rights, you've lost your lien rights, and then an additional 5 days after you filed. But then going forward, you have lien rights in whatever work that you perform going on. So it's not a complete loss. So if you're on a project for an extended period of time and you've made a mistake and you haven't filed a preliminary notice, but you're still performing work on the project, file that preliminary notice, because you still can preserve partial lien rights on the remaining work that you perform. Okay? Does that make sense? If you file more than 20 days, you lose your rights on the 20 days plus 5. So, even if you file, you still are going to, if you file on day 21, you're going to lose credit for 21, 22, 23, 24, 25, and then you start getting credit on 26 going forward for lien rights. That's how that kind of works. Okay, well, what do you include in your preliminary notice? There's certain statutory requirements, information you need to include with that preliminary notice when you fill it in on the state construction registry. Number one, you got to put your name, address, and email address and telephone number. You need to put the name and address of the person who contracted with you. So if you're a sub, you want to identify the general contractor, if that's who your contract's with. If you're the general contractor, you want to identify the owner information. You want to include the name of the record or reputed owner of the project. So you're going to want to find out who the owner of the project is. Okay, so you can input that information in. And the name of the original contractor under which the work is performed. So if you're like a second-tier subcontractor, you're going to want to find out who the general is. So you can put that information in. That's why it's important to know where you fall at the beginning of a project, who's on the project, who the owner is, who the general is, because you need that information in order to put that in your preliminary notice. And then you want to identify, this is perhaps the most important, the project address or description of the location of the project. So you got to have the address, or if you have a parcel number, from the recorder's office or something, then you're going to want to put that in, because you want to make sure that your preliminary notice links up with the right project. Because what happens if your project links with some other project that you have not performed work on and you put the wrong address in? Well, you're probably going to lose your lien rights, because it's going to link to a different property and it's not going to show up on the correct property, giving everybody notice that you're doing work on there. Okay. You also you got to identify the county where the project is located, and one of the following: tax parcel identification number of each parcel included in the project. So if you're on a project that has numerous parcel numbers, you got to identify each parcel number. Okay. Or you can put in the entry number of a previously filed notice of construction loan, if there's one on that project that you're aware of. You can put the entry number of a previously filed preliminary notice on the same project that includes the tax parcel identification number of each parcel included in the project. So if you're a subcontractor, you've got a buddy that's performing work on the same project, and he or she has already filed a preliminary notice, you can say, hey buddy, hey, can I see your preliminary notice? I'm doing work on the same project, and you can kind of piggyback off that information. Buyer beware though, if your buddy's made a mistake on his preliminary notice, that's not going to excuse you because you relied on his information. You're going to be held to have known that information was correct or incorrect. Or you can include the entry number of the building permit issued for the project. So you don't have to include all of those in your preliminary notice, but you have to include at least one of those. Yes?
Timeshares.
Condos, right?
I got bit bad this year. Did work on 60 timeshares. Filed one notice. Found out after I had to file 60.
Yeah, multiple units, like timeshares, condominiums, apartments. You just can't file on the one general preliminary notice. You've got to file on each individual parcel of property, and those can be kind of a nightmare sometimes. But that's what you have to do. It's tough. Okay, so what are some of the things that you could look for when you're filing your preliminary notice to help guide you? You're going to want to look and see if there's a notice of construction loan. After recording a trust deed, a lender is supposed to file a notice of construction loan, and that's supposed to put everybody subsequent on notice that, hey, this project's being financed, this is who's financing it, we're here, we're in first place, we've got the number one priority. If they don't file a trust deed before contractors or subcontractors perform work, then the bank, they're going to lose their priority rights over all the generals and subcontractors on that project. Okay, that happened a lot. That used to, back when things were like in the boom times, like the early to mid 2000s, banks were getting sloppy, and they were loaning out money, but they weren't filing their trust deeds until sometimes weeks after they'd funded a project. And in the meantime, you had work going on the project and generals and subs filing preliminary notices. And so you have, and basically, if you've got one contractor who's in front of the bank all contractors are in front of the bank. Even if, the subcontractor comes in after the trust deed was recorded, that subcontractor would have priority over the bank. And so banks were losing out on their priority because they were failing to record their trust deeds timely. And that was a real problem for them. And a lot of generals and subcontractors, as a result, got paid before the bank, which is good, in my opinion. Yes?
So will any construction loan that information be on this website, or is it only found in the recorder's office?
It should.
And I do have another question.
That's a good question.
Because a lot of times banks will do a one-time close on a construction loan. So is there a trust deed recorded prior to construction?
They have, yeah, and that's a good question. So this notice of construction loan, and we're going to talk about this here in a little bit, file on the SCR is actually kind of optional. They're supposed to do it, but for some reason the legislature, there's no penalty if they don't. Where you're going to want to really look, where they have to file it, is with the county recorder. So if you're looking on the SCR for a notice of construction loan and it's not there, and you go, great, I'm going to get priority over the bank, but in reality, the bank has actually filed their trust deed with the county recorder, then that bank's going to have priority over you. Does that answer your question? So you have to go to the county recorder to determine where your true priority stands.
Do you want it in a situation where there's a one-time close, where the person who is obtaining the construction loan closes on the loan after construction is complete? Is there a trust deed filed prior to that?
There should be a trust deed filed. If they've funded a project and they haven't filed a trust deed with the county recorder, then they're in trouble priority-wise. They should file that early on, before that, even on a one-time close situation. Otherwise, they may lose their priority. Is there another hand?
To help her out, I've done a number of one-time closes for clients on the general. They trust deed it right away. All it is the construction. It's not a construction loan. It's a long-term loan. They finance it out of that. It's a two-part thing. And then at the end, they have a kind of a notice of withdrawal from anything. They kind of tighten it up at the end. But for all intents and purposes, it's filed with the county and there's a trust deed.
Yeah, and that's what you typically see is they file it right away. Yeah. So be careful. If you don't see a notice of construction or a construction loan on the SCR, that doesn't mean that you have priority over the bank. They're supposed to file it, but they don't have to. They do have to file it with the recorder's office. So you want to check with the recorder's office. If you can rely on other preliminary notices, but like I said, make sure that information is correct. The law, it's not super hyper technical. There can be mistakes made on your preliminary notices. What the law is looking for is they want you to provide enough information that the owner, banks, and other people have fair notice that you are performing work on that property. So if you make some mistakes in your preliminary notice, it doesn't mean that it's fatal. But if you make enough mistakes or you omit enough important information where other people can't tell that you are doing work on the project, then you could be in trouble. But you want to do your best to make sure the information you're relying on is correct, especially the more crucial parts of it, including name of the owner and project location identification. You can also look for building permits. Typically, if a building permit is required on a project, the city or county or town that's issuing the permit, they're supposed to file a building permit within 15 days of issuance of that building permit. And that building permit's going to have a lot of the information on it, like the owner information, general contractor, location of the property. All right. Building permits issued after August 1st, 2011 must have the following. Name and address of the owner of each parcel of property in which the project will occur, the name and address of the contractor, the county in which the property is located, and the tax parcel ID number. Okay. You can also look at notices of pre-construction service. As I alluded to earlier, notices of pre-construction services are typically filed by architects, engineers, people that are performing design work on a project and not actual physical work on that project. But that's going to also have the required information that you can look for and maybe rely on in filing your preliminary notice. So going back to the notice of construction loan default. So the lenders, it says required to file on the SCR within 5 business days after a notice of default is filed for recording. But like I said, there's no penalty to a lender if that lender fails to file a notice of construction loan default. So what that means is if you know that there is a construction loan on a project that's being funded, if the owner is in default of that loan and stops paying on it or whatever, the bank is supposed to file a notice of construction loan default within 5 days of the default. And that's, to help put everybody on notice, this owner's in trouble, this project's in trouble. And hopefully banks are doing that when it happens. But if they don't, there's no penalty if a lender fails to file. And so that can make life difficult for you guys if you're on a project, especially if you're a lower tier subcontractor who doesn't have contact with an owner and doesn't hear about default issues. You might be performing work while a loan is in default. And if the loan's in default, chances are you're not going to get paid. Let's talk a little bit about construction lien priority. This is kind of a timeline we've created of events in terms of filing a preliminary notice and filing of a lien. So you have your first work here. Let's see if this laser works. Nope. You have the first work right there, the far left side. Okay. After the first work is performed, say by an excavator, say the excavator files the first preliminary notice before the bank records its trust deed. Okay. After that, you start getting other contractors coming on the project to perform work, and second notice, preliminary notice is filed. Okay, that's after the trust deed. Okay, project is completed. Owner files a notice of completion, letting everybody know this project's been completed. There's a notice of construction loan default. We'll talk a little bit about this later, but if a notice of completion has been filed on the state construction registry, that means you only have 90 days from the completion of the work to file a lien. Okay, so if a notice of completion has not been filed, you have 180 days after a project has been completed to file a lien. When I say project has been completed, I'm not talking about your work, if you're subcontractors especially. So if you're an excavator and you finish your work, the 90 days or the 180 days does not begin when you finish your work. That 90 days or 180 days, depending on whether a notice of completion is filed, begins when the entire project is completed. We'll talk about what the law deems as completed, because when is a construction project really completed? But we'll talk about that. When you file your lien, if you file one, you have to send notice to the owner that you have filed that lien within 30 days of filing that. If you don't send that notice, you don't lose your lien rights, but you do lose your ability to claim attorney's fees in case you win on your lien. Because a mechanic's lien, if you prevail, Utah law will award you your attorney's fees if you're the prevailing party in a lawsuit for closing on a lien. But if you haven't sent notice, if you didn't send notice to the owner within 30 days of filing your lien that, hey, owner, I've done work on your property, I filed a lien, I haven't been paid. If you don't do that, then while you can get the principal amount back that you're owed, you can't get attorney's fees. After you file your lien, you have to file a lawsuit on that lien within 180 days if you haven't been paid. So say you file your lien and 180 days goes by. If you file on day 181, you still haven't been paid, and you file your lawsuit on day 181, that's going to get kicked out of court. You want to file before that, okay? Otherwise, you lose your lien rights. Any questions on the timeline? We're going to talk a little bit more about this, but
Does Utah allow the defaulting party to post a bond and just kind of
I'm sorry, does Utah law allow a defaulting party to post a bond to get around the lien? Yes. Yes, that's called alternate security, where if you're like, say, like you're a general contractor, maybe you have a subcontractor who you have a dispute with, and the sub claims you owe money. Say you don't believe you owe money, or there's defective work, but he files a lien anyway. You got an owner who's mad at you because he's got a lien on the property that he's paid you for, for that work. You as a general contractor can bond around that lien. Okay. And I think this presentation has a little bit on how you do that.
All these laws apply to general remodeling
Yes.
situations too, where you're just dealing directly with the owner?
Yeah. So the question is, do these mechanics lien laws apply to even if you're doing just remodeling work where you have, you're the only one on the project dealing directly with the owner? Yes, they do. If you're just doing remodeling work or whatever, and you have your contract with the owner, you still have to do this, or you lose your lien rights. You still have a breach contract, all right? So understand, if you don't have lien rights, that doesn't mean you're totally up the creek. You still have breach of contract rights against the contracting party who hasn't paid you, but you want to have your lien rights, because if the person you have a contract with doesn't have the money to pay you, and the only money is tied up in the property, well, that's what you're going to have to try and access to get paid.
I had a situation with a homeowner in California, and I think he tried to remodel it to sell it, and then it didn't sell.
Mm-hmm.
And he can pay all the contractors, so I didn't follow any of these rules, but I filed a lien anyway. No one could stop me from doing it, and I don't know, I finally got paid like a couple of years later. It just hung out on there.
Yeah.
I guess they have to prove that your lien's not good.
Right.
And
Yeah.
he didn't know how to do that, so I got a $12,000 check like years after I thought that it was written off.
Yeah.
But he finally sold that property, and I got paid.
Yeah, that's good. So yeah, if you have any doubts on whether to file a lien, you should file it, because if your lien is wrongful, then the other party has certain legal obligation to tell you why it's wrongful and why. And if it is wrongful, in fact, and you don't remove it, then you can become subject to some pretty stiff penalties if you fail to remove it. But like in that situation, you filed the lien, and it was in California.
Yeah.
And who knows what California's laws are in regards to liens? Maybe you could just file it anyway. Maybe they looked at it and it wasn't wrongful, and it was a totally valid lien. If you were to do that in Utah, and somebody came to me and said, listen, somebody's filed a lien who didn't file a preliminary notice, then I would write a letter to the person who filed the lien saying, listen, you don't have lien rights. This is why, and you've got to take it off within, I think it's 20 days in Utah, or else you're subject to some stiff penalties. So you have to be careful that way. But that's good that it worked out for you, because that's, in the end, that's what you call justice. You did the work, you conveyed value, you're supposed to be paid for it, you got paid. So that's a good result. All right. Is there another hand? I don't know if I missed one. Okay. Construction lien priority continued. Like I said before, all mechanics liens are on the same footing and have the same priority. Okay. So like I said, if you're the excavator, don't think that you're, always have priority over all the other subcontractors because you're first on the project. That's not the case. You have the same priority as the other contractors. Okay. So if you're on a project and you have a lien, and then somebody else has a lien who performed work after you, that doesn't mean you're going to get paid first. You're on the same footing as the other ones. Liens relate back to the time of the first preliminary notice filing and have priority over subsequent encumbrances. What that means is, as it relates to contractors, like I just said, if one files before a bank, all have filed before a bank. Even if that's not technically the case, all of them are going to jump the bank. Order of sale proceeds. Laborers get paid first. Okay, so if there's a general laborer who hasn't furnished materials, who's just on the job, they're going to be recognized as first to get paid. And then subcontractors, suppliers, and original contractors. So there's a pecking order within that. Okay, let's talk about the buyout option that's kind of new. So it used to be that a bank, if a bank filed a trust deed after one of the first contractors on a job, then all subcontractors or contractors performing work had priority over the bank. and the bank could do nothing about it other than pay out the subcontractors. Well, I guess the bank had a pretty powerful lobby with the Utah legislature because they crafted a law where the bank can now buy out the position of contractors that are before them and then wipe out everybody subsequent. So if you have an excavator who files a preliminary notice before a trust deed is filed, and then you've got a bunch of subcontractors who have filed preliminary notices after the trust deed, those used to have priority over the bank no matter what. Now, the new law is the bank can come in and buy out the excavator, pay him in full, whatever, and then if he does that, that wipes out the priority of all subsequent contractors. So now you're behind the bank. So that's a new law, which is, well, it's not new anymore. It's a few years old, but
I think it has a good lobby.
yep, they do. They do. I don't like it, but they do. So the lender can acquire first priority position if the first lien claimant with priority accepts payment in full for work performed before the lender's trust deed and withdraws a preliminary notice. So if you're the excavator and you have priority over the bank comes in, pays you out, you have to release your preliminary notice, and then that puts all of the preliminary notices behind the bank. And then, but if you're the excavator, be careful. So if you're the excavator and you're still performing work on the project, say you filed a lien, but you're still doing work, and you get paid in full for the work that you've done, okay, if you then release your preliminary notice and you're still doing work, what do you have to do? Can you rely on your old preliminary notice that you've just withdrawn? No, you got to file a new one if you're the excavator. So if you're still doing work or you're a contractor that's still doing work, this would apply mostly to generals, I think, because generals on the project throughout. And if a general has the first preliminary notice and has done $50,000 of work on a $100,000 project, the bank comes in, pays him $50,000, he releases the preliminary notice, then general does another $50,000 of work. After that, general's got to file that preliminary notice again, or else the general's going to lose out on the lien rights for the remaining work.
Again, then?
What's that?
Then you're behind the bank.
Then you're behind the bank. Yeah. I'll tell you, most projects you're going to be behind the bank anyway. Now banks are a lot more careful now because they got burned. They got burned several times on some huge projects here in Utah. They got burned because they were sloppy in how they recorded the trust deeds. So they're a lot better about it now, but it still happens. Notice of completion. So a notice of completion is basically a notice that a original contractor, owner, lender, surety, or title company can file with the state construction notice, and they can't file it until the project has been completed. Now, this is something you don't see a lot. You don't see a lot of contractors, lenders, owners filing notices of commencement. Number one, they may not know about it. Number two, it's not legally required, so they don't care. Some of the more sophisticated owners and lenders, they will do it because what it does, it shortens the time for filing a mechanics lien. Like I said on that timeline, you typically have 180 days from the time a project is completed to file a lien. Does everybody understand? A preliminary notice is not a lien, okay? So preliminary notice just gives you the right to later file a lien. So after you file your preliminary notice, you actually at some point, if you don't get paid, you're going to have to file a lien, and that's a separate document. If they file a notice of completion, and then that shortens the time period for filing your lien from 180 days from the time the project is completed to 90 days. So it cuts it in half. So does that make sense? So say a project is completed, there's a notice of commencement filed, you have 90 days from the time that project is completed to file your lien. If no notice of commencement is filed, you have 180 days to file your lien. And that's significant because if you get it in your mind that, hey, I have 180 days after the project's completed, I'm going to work with the owner or with the general, I want to preserve the relationship, and they're just waiting for funding, waiting for payment. If you get strung along, and if you think that you have 180 days, but in reality on the project, they file a notice of commencement and you only have 90 days, and if you miss that deadline, you miss out on your lien rights.
Keep on saying notice of commencement. You mean notice of completion?
I'm sorry, notice of completion. Sorry, thank you for that clarification. So you're going to want to check for that notice of completion at the end of a project.
So where is that required to be filed, or is it like where there's no penalty type thing either, or is?
Right. It's not required. It's not required. It's optional.
But that'll be, is it required to be filed with the county or the quarter?
On the SCR. On this, that's required to be filed on the SCR. Yeah.
Does the SCR notify other people that these things are?
No.
being recorded?
Yeah, you wish they would, like-
You have to look at their site.
Yeah,
every
don't you
day.
wish they could, wouldn't it be, it's too logical that if you've linked to a project that's too logical that every time something's filed, they could like send you an email notifying you of a filing. That would be just too easy, right? They don't. So you have to kind of check. And if you know a project's being completed, you want to go on there and check every few days or so. Yeah.
Is that just on notices of completion or on all notices? I get emails all the time on projects for other subcontractors that file preliminary notices.
Do you get notices? Do you get emails from the SCR on the preliminary, from the SCR on that? Have you ever gotten one for a notice of completion?
No. So it's just on notice of completion.
Probably, I think so, because it's not a required filing. So if it's not a required filing, I don't think they're going to give you notice. So you're going to want to check on that. So on the other hand, yeah.
What if a project goes bankrupt before it's complete?
If they actually file bankruptcy,
Yeah, I mean, if you've got a great big building that owner runs out of money and abandons the project, no one's getting paid anymore, everyone stops working, at what point is it complete? Can you file a lien?
you should file a lien immediately. But because I think there are some exceptions for abandonment of a property, but you still got to file it. Of course, if it's an actual bankruptcy, there's what's called automatic stay. So if somebody files bankruptcy that owes you money, you cannot take direct collection attempts against them to try to get paid, or else you're in violation of the the automatic stay rule, the bankruptcy laws. So you have to kind of work through the bankruptcy court. So if you've received a bankruptcy notice, then now your claims goes through the bankruptcy court, and you'll get information from the bankruptcy court saying, hey, look, if you have a claim, this is what we need, where you send it, and the time period. But if it goes if the project goes south and you just know it's in trouble and you haven't filed a lien yet, you should file your lien, like immediately. Another hand? Okay, filing a notice of completion also shortens the time for preliminary notice. So you remember I talked about you have 20 days from the time you begin your work to file a preliminary notice, or you lose your lien rights on the work performed within that time. So this is something we don't see often because you can't file a notice of completion until the project's completed. So for most subcontractors, you won't have to worry about this, but if you're always on the tail end of a project, if you're a painter or a finished carpenter, this could really affect you, or a general contractor that's on. So if a project is completed and the day it's completed or the day after, the owner files a notice of completion, if you're the painter and you haven't filed your preliminary notice yet, you may think, hey, I have 20 days to file it. I'm busy. I got to go do this other project, whatever. I'll file it, in a couple of weeks because I have 20 days. That's not necessarily the case. If a notice of notice of completion has been filed, that shortens your time period from 20 days to 10. Don't ask me why. It's stupid. I don't make the laws. I didn't make the laws. I think some of them are ridiculous. I think they make this overly complicated and technical on some fronts, but that's the law, and it is amazing. It's this is amazing. So if you're on the tail end of a project, I think it's a matter of course, once you begin your work, because they can't file a notice of completion if the work's not completed. If you're on the project, you're performing work, just file your preliminary notice, within a day or two after beginning work as a matter of course. Don't think, hey, I have 20 days. You may have 20 days, you probably do, but if they file the notice of completion, you have 10. Let's talk about when final completion occurs. Because that's an interesting concept, right? Because in a construction project, when is a construction project complete? Well, this is what the law says. the law will deem a construction project complete when there's an issuance of a permanent certificate of occupancy if required. So there can be punch list items left or whatever, but if there's been a permanent certificate of occupancy, that's when final completion occurs, even if there's punch list stuff or some other stuff going on at the tail end of the project. Well, not every project requires a permanent certificate of occupancy. So if there's no permanent certificate of occupancy required, then the date of final inspection by the local government entity, that is the trigger for final completion. If no final inspection is required and no permanent certificate of occupancy is required, then the date of final completion is when there remains no substantial work to be completed to finish the work on the original contract. That's where it kind of gets murky, okay? Because what is substantial work? Punch list items could mean substantial work if it's something that affects the owner's ability to use the property and habitate it, whatever. But if you're on a project that doesn't have final inspection requirements or certificate of occupancy requirements, that's going to tell you that you should, get your lien filed as soon as possible if you haven't been paid. That might upset an owner, but I would hope that owners would understand that you don't make the laws, that you're required to do certain things in order to protect yourself, and that you're more than happy to release it once you get paid. And so, you have to make the decision of when there's no substantial work to be performed. But basically, if an owner can use it and habitate it and whatever, probably the law is going to recognize that substantial work has been completed. And there's, yeah.
Would a temporary C of O also affect that, or it has to be permanent?
It's got to be permanent. If there's eventually a permanent required, you go by the permanent. Temporary, yeah, that would not trigger it if a permanent is required. Oh, here's the answer to your question about abandonment. If an original contract is terminated before the project is completed, the last day on which substantial work was performed under the original contract. So that would apply to abandonment. A contract when it's abandoned, or a project when it's abandoned, basically that's the contract has been terminated. There's been a breach there. So that would be, kind of the answer to your question. Okay, notices of completion continued. So if generals can file notices of completion to shorten the time the subs have a right to file liens. So if you fall into that category and the owners asked you to file a notice of completion, this is what the types of information they must include. Tax parcel ID number of the project, or if there's multiple tax parcel ID numbers, you have to include those. Or the entry number of a preliminary notice on the same project that includes the tax parcel ID numbers. Or the entry number of the building permit issued for the project. So if you go into the state construction registry and your general owners ask you to file a notice of completion, that's some of the information that you can include in the notice of completion. As to government projects on notices of completion, you got to also show lot or parcel number in the project and the project number assigned by the SCR. Let's take a short break, and after we come back, we'll talk about filing and perfecting construction liens. So we've gone through and talked about preliminary notices, notices of completion, priority. Now you're at the point where, shoot, I haven't gotten paid. I'm going to need to file a lien. We'll talk about how you do that and when we come back. So let's take, I've handed out most of you, it's just kind of a quiz on mechanics liens. This is some of the stuff we've covered so far and some stuff we'll be covering here, but that's just for your benefit to fill out. And if you have any questions on the end as it relates to the answers, maybe we can go through it at the end and make sure you feel comfortable about the answers. This picture, if you don't recognize, this is from I think that's from Raiders of the Lost Ark. If you ever seen it at the end where they pack up the Ark of the Covenant and put it in a big warehouse and all these boxes. I was just joking about this this scene last week with some attorneys at my firm. We had to go down to Tampa, Florida, and to review hundreds of boxes of documents to respond to some discovery requests that were sent to us by the other side, and the court said we had to go down there and find them. And so we looked at about 600-700 boxes of documents in a self-storage facility, and then we found out from the client who's bankrupt, and they only have one employee left that's kind of tying up the bankruptcy and helping out with the trustee. He found out that there was an Iron Mountain storage facility that had another 7,000 boxes of documents that may or may not contain documents responsive to the other side's requests. And so we tried to get, I pictured the Indiana Jones, Raiders of the Lost Ark. I pictured this scene that's what the warehouse would look like, and we would have to go through all these documents. Luckily, the client who was bankrupt owed a bunch of money to the storage facility, so they wouldn't let us look at them. He let me go back and say, listen, this is kind of what it looks like, and you know, by the way, your client's boxes are not only at this facility, but they're spread throughout other facilities in the southeastern United States, and it would take us weeks to locate them and get them together. But he took me back to the storage room, and it kind of looked like this, except for that the shelves were actually higher, just like little walkways like this with boxes. Not just my client, Iron Mountain stores, you know, there's tons of people's, but that's what the aisles look like, and they had like boxes stacked up to here, and I'm just like, thank my lucky stars that they wouldn't give us access. So anyway, so let's talk about, I think she came. Who didn't get one of these? Entire back rows. She just pass these down and back. Oh, and give me one too. Actually, thanks. Yeah, so let's talk about filing and perfecting liens.
You have any more?
Oh shoot, are we out? Dang it. Hold on.
So I guess you can shut them down.
She stepped out. We'll get them to you at the break. Sorry. All right, let's talk about filing and perfecting construction liens. And perfecting means what you do with it once you file it, what you have to do in order to enforce it. So lien filing deadlines to be aware of, like I talked about, if a notice of completion has been filed, you have 90 days from the time the project is completed. Not your work, but the time the project is completed. After you file the lien, you got to send a copy of the lien to the owner within 30 days of filing the notice. Now, if no notice of completion has been filed, you have a 180 days from final completion to file a lien. So a lien is separate from a preliminary notice. It's a separate document that you don't file with the SCR, okay? When we get to the lien, who do you file your lien with? County recorder. And you file it with the county recorder in the county where the project is located. Not where you're located, not where the owner's located, unless he lives where the property is. You want it ties to where the project is located. So what do you include in a lien? Typical things. There are places that can prepare liens for you. You know, if you don't feel comfortable doing them yourself. I'm sure Ross or some people here know of some places that do them. Contents of a lien: name, address, and phone number of yourself. You're the claimant. The owner's name, owner of the property. The debtor's name. The debtor obviously is who owes you the money. So if you're a subcontractor, who do you put down as the debtor? Whoever owes you money, which is probably the general. Okay. Or if you're a general, you're going to put the owner's name if the owner owes you money. You got to put the amount that you claim is owed your due. That's pretty important because if you overstate your lien amount in bad faith, then you could be subject to certain penalties for overstating your lien. First and last dates of your work and lien recovery information acknowledgement if it's a residential project. We'll talk a little bit about that. So that's the basic. Yep.
Excuse me, you skipped property description.
Oh, I'm sorry. Yeah, that's kind of important.
It's not just the address.
That's kind of important. It's not just the address, okay? If you just put the physical address down there, probably not enough. You need to find the legal description or parcel ID number, okay? You can find that at the county recorder or on the SCR from other liens that have been filed. But yeah, physical address, that's typically not enough. You got to do something more than just that for the property description. Thank you. Okay, lien filing issues that we see a lot. Inaccuracies in the lien. Substantial compliance is sufficient. So like the preliminary notice information, if you substantially comply with the lien notice requirements, you'll be okay. But if you omit something really crucial and important that affects an owner's or a bank's or anybody else's ability to identify that you are actually performing work on the project, you're going to run into problems. Like I said, where to file the lien, you file it with the county recorder where the property is located. If you have filed a lien and there's been changes to your lien after, or you have been paid partially, you can go in and amend your lien to change the amount that you're owed, and you should. You shouldn't leave a lien on there for an amount that you're not owed. You get in trouble for that. Or if you come up with additional information that you omitted from your lien, you can do that. You got to make sure, though, that you do the amendment within the original time frame for filing the lien. So, say the project is completed, there's no notice of completion filed, you have 180 days to file your lien. If you file your lien on day 179 and then on day 181, you figure out that you have the wrong address, or you have the incorrect owner, or you've overstated your lien amount, then you can't amend it within that time. With the exception of if you're changing the price, the dollar amount, they typically are okay with that, because that typically means sometimes people will file a lien and then after the 180 days passes, you're kind of working with the owner or whatever to get paid. They partially pay you. You could go in and amend the price lien downward. That's typically okay. Enforcement of liens. Okay. Once you file a lien, the important trigger date is you have 180 days from filing your lien to file a lawsuit if you're going to file one. Hopefully, when you file your lien, if you have to file a lien, hopefully you get paid, in a timely manner. But sometimes you don't, because there may be a bona fide dispute or there may be issues with funding or whatever. You have to be aware that you got to file that lawsuit within 180 days from the time your lien was filed. You have to all file the lawsuit in the county where the property is located. So if you've done work, if it's out of state, and the owner lives in Utah and you live in Utah, but the project is out of state, you don't file in Utah. You have to file in the state where the property is located. Okay.
Who came up with all these rules?
Bureaucrats.
I'm just trying to figure out.
Lawyers.
Contractors wanted.
Lawyers who don't practice law. Serious? No, I'm serious. Like, it's your state legislature.
It seems like they don't totally protect contractors that much to have all these time constraints and rules. If somebody decided to put all these rules on here who didn't want to pay contractors.
It can make your life difficult. And yeah, no, the answer to your question are your state legislatures, your representatives. And they're the ones who make the laws. Yeah, so if you have an issue with it, I mean, get a group together and make a run at it. But there are, I have mixed feelings about it. I think they're a little too technical and a little bit. If you as a contractor, if you become familiar with these rules and deadlines, I know it's a lot of information now, but if you make it a part of your business practice and you have a timeline of, okay, this is what I have to do on each project, it becomes really easy. I mean, it takes some time up front. It's like setting up a business. It's really painful at first, but once you get the hang of it, it just becomes second nature. Same thing with filing liens. And and complying with the deadlines. It becomes second nature to you. You just learn them and you know them, and it can become, you know, an asset to you. But it can be frustrating because there are a lot of deadlines, a lot of dates, a lot of technicalities. You know, the rationale that the legislature would give to you is that the deadlines are for purposes of protecting owners and banks, to make sure that they know who's performing work on a property, and so that those performing work on a property give the right information to support their claim that they're working on a property. But it can be kind of difficult at first, but once you learn it, it's important. Okay. If you ever get to the point where you have to file a lien, or that you have to foreclose on a lien, you can represent yourself, but I would highly recommend you get an attorney because it becomes pretty technical. But if you've got to file a lawsuit, you got to file the lawsuit in the county where the property is located. You also have to file a lis pendens, which is a legal document. You don't file the lis pendens with the court. You file that with the county recorder, and that puts everybody on notice that there's not only a lien on the property now, somebody has actually gone to this extent of filing a lawsuit trying to foreclose on the property, and that gets the attention, the real attention of, you know, banks and anybody else who's on the property, and, you know, hopefully that can get things resolved. If you don't file a lis pendens and you got to file that lis pendens within the 180 days of the lien's filed. So if you file a lawsuit on day 179 and then you file the lis pendens with the county recorder on 182, your lawsuit's going to get dismissed.
Can I ask a question?
Yeah.
So do you have to get a judgment before you do the foreclosure?
Yeah, you have to get a judgment. You have to get a judicial decree from a judge that you have permission to go to a sheriff with an order directing the sheriff to sell the property. Construction lien filing time, we don't see that happen a ton. Typically, by the time if that happens, things typically get resolved, but sometimes they get to that. It gets there sometimes. Construction lien filing timeline. Okay, so commencement of the work, you file your preliminary notice within 20 days. The work's completed, a notice of completion is filed. If the notice of completion is filed, you got to file your lien if you still haven't been paid within 90 days. If no notice of completion is filed, you have 180 days. Once you file your lien, send notice to the owner within 30 days so you can recover your attorney's fees if you win at trial. And then within 180 days after filing your lien, you got to file your lawsuit. By the way, I think there's a link. You might want to talk to Ross or somebody here, but I think there's a link on the HBA website where you can access the materials today that you've seen today. So you can go back. Ask Ross or somebody, because it's supposed to be able to link it somewhere. I think it takes it to it, but you know, so you can go back and look and study this if you need to. Alternate security. This is what we were talking about earlier. If you're a general, you can actually bond around a lien. You know, sometimes an owner will maybe demand it, or you might have a contract that requires you to bond around liens. So if you do that, you got to get the alternate securities. You call a bonding company, say, I've got a lien on this project, got to get rid of it. They will help you bond around it for a fee, of course. You must file, once you do it, you must file a notice of release of lien with information on the alternate security within 90 days after the foreclosure lawsuit is filed. So the amount of the bond, the alternate security that you have to get, has to be 150% of the amount claimed in the lien if the lien is $25,000 or more, 175% if the lien is between $15,000 and $25,000, and 200% if less than $15,000. So the amount of the bond is going to be that you have to get is going to be higher than the amount claimed, and that's because of attorney's fees, interest, and costs that may be associated at the end of the day if the lien is found to be valid and the surety company has to pay out. So once alternate security has been provided, you've got to serve a copy of the notice of release of lien on the lien claimant within 30 days of filing it. So if you are attempting to get the lien off of the property and you get that alternate security, serve the other side with a notice of release of lien within 30 days. And the lien claimant, that now starts the clock. The lien claimant now has to amend the lawsuit to include the alternate security within 90 days of service of the notice of release of lien. If they don't, they lose their rights not only on the lien, but on the alternate security. I saw that happen once where the lien claimant did not amend their complaint to include the alternate security within the 90 days, and the court kicked out the entire claim. If notice of release of lien is not served, the lien claimant must amend the lawsuit within 6 months of discovering the notice of release of lien, but must amend within 2 years from the date the notice of release of lien was recorded. So that's important to serve it, because if you don't serve notice of the alternate security, then they get 2 years instead of 90 days to amend the lawsuit to include the alternate security. Okay, let's talk about avoiding civil and criminal penalties for wrongful liens. You do not want to file a wrongful lien. You do not want to file a lien just in spite of somebody that you're working for. If you're not getting along with the owner, you don't want to go around filing liens unless there's a valid legal basis to do so. Because if you do that, you can be penalized pretty heavily. So the abusive lien statutes in Utah Code Annotated 38-1A-308. What are some examples of abusive liens? If you claim more than you're entitled to. Now this doesn't mean, what happens a lot is somebody will claim a certain amount in a lien and they go litigate it and it's found that they get only 50% of their lien claim. That doesn't mean that you filed an abusive lien, because there may be a bona fide dispute over whether you're entitled to the amount you claimed in your lien versus what you actually get. But if the court finds that you have overstated your claim on purpose and you had no evidence to support that claim, then you could be liable for twice the amount by which the lien exceeds the amount actually due. So if you file a lien for $100,000 and you're only entitled to $50,000, and you knew that when you filed your lien, then you could be liable for what, at the end of the day, $100,000 for filing an abusive lien. Okay? If you get paid, if you file the lien and you get paid in full, you have 15 days to release your lien. And that's important, because if you get paid and you keep your lien on there, that's going to affect the owner's ability to refinance or sell or whatever. And if you have a lien on there that you've been paid for, you could be in trouble for that. Okay, let's talk about SCR requirements for government projects. Now we're talking about bond claims. So we're done talking about liens for now. Let's talk about SCR requirements when you're performing work on a government project. You don't have lien rights on government projects, on public projects. You have bond claim rights, hopefully. Okay, so this is the twist. For some reason, the Utah legislature requires notices of commencement on public projects, okay? That used to be required on private projects too, but with the laws that were passed a few years ago, like I said, they took away notice of commencement requirement on private projects, but they left it for public projects. So if you're on a public project, you're going to want to look for a notice of commencement. Now, as a subcontractor, you don't have to file these. You don't have to file them if you're a general either, but an owner or a lender is supposed to file one of these. Yeah.
Teach a carpentry class. We build a house every year. Is that private or public?
Where are the funds coming from? That's probably a public project. Yeah. I mean, well, yeah, because it's a school district, special service districts. It'd probably be considered, if it's public funding, it's coming from the public. It probably is. If you're not getting paid on it, then yeah, it's a bond claim. So before you do work, you want to request a copy of the bond. Just say, hey, I want to see the copy of the bond. Notice of commencement. Original contractor or owner required to file notice of commencement with the SCR within 15 days after commencement of physical work. Okay? So after the work begins, the general or the owner have to file a notice of commencement within 15 days. What happens if they don't? Well, subcontractors and suppliers, no, you don't have to file a preliminary notice on the public project, okay? So if you're on a public project and no notice of commencement has been filed, you don't have to file a preliminary notice. Should you still file one just in case? Yeah, I'd file one just in case, just good business practice, but you don't have to. Sometimes you'll see on public projects duplicate notices of commencement, which means sometimes a general and an owner will file one. They're different notices of commencement. The law recognizes the first one filed as the correct one. So if an owner files one on day 14 after work has been started, and the general files one on day 16, the law is going to recognize the one that was filed on time and find that there's a valid notice of commencement. What should be included on a notice of commencement? Owner's name, address, and email. Or general contractor's name, address, and email. Payment bond surety's name, address, and email. Or a statement that a payment bond was not required for some reason. The project address, if it reasonably identifies the project. Or the name and just general description of the location of the project if the address does not reasonably identify the project. Boy, that's just vague. But what they're looking for is tax parcel ID numbers, actual property legal descriptions that you can get at the recorder's office, physical address, but that can be tricky. General description of the project and government project identifying information if that's provided by the government. Preliminary notice. So if a notice of commencement is filed, everybody, including generals, must file a preliminary notice. Same rule as for private projects. You have to do it within 20 days of your first work, and if you don't, you lose out on those 20 days plus 5. If there's multiple notices of commencement on a project, you don't have to file on all notices of commencement. You just file one preliminary notice on one of the notices of commencement, and that will be found to be valid. Exceptions to filing preliminary notice, no, if there hasn't been a notice of commencement filed. Persons working for wages, so laborers, if they're just working for wages, they don't have to file a preliminary notice. But if you're a subcontractor, general contractor, supplier, you're not going to fall under this category. This is meant for maybe like handyman, something like that. Those who provided labor, services, materials, equipment more than 15 days prior to the filing of a notice of commencement. If for some reason you perform services on a government project more than 15 days prior to the filing of a notice of commencement, then you don't have to file a preliminary notice. This doesn't happen very often because typically you're not going to be on the job until a notice of commencement has been filed or within the 15 days. Where you see it more is with design professionals. Okay, what do you put in your preliminary notice? Basically the same information as on private projects. And there it is again, we just talked about it. Basically, you're identifying information. Identifying information of the contractor you're contracting with, the owner of the project, project address or description of location of the project. Okay, lien recovery fund. These are for residential projects, for homeowners and stuff like that. As contractors, you guys pay into the lien recovery fund. That gives you certain rights under the fund to make claims if you don't get paid. The issue typically is you have a homeowner, then you have a general contractor who's contracted with the homeowner, and then a number of subs who perform work on behalf of the general contractor. A homeowner pays the general contractor in full for all the work. The general pays some of his subcontractors, but for some reason doesn't pay one of the subcontractors. And then, so what happens to this sub? Sub can lien the project to get paid and can sue the general contractor for breach of contract. But But that leaves the homeowner with the dilemma. Are they eventually going to have to pay this sub twice if the general, say the general goes under, goes bankrupt, and disappears? Now the sub's looking solely to the homeowner for payment. A homeowner who paid his or her bills in full, but a sub who has not been compensated due to the fault of the general. So that's the reason why the legislature created the Residents Lien Restriction and Lien Recovery Fund Act. Let's talk a little bit about that. This is like a very, has anybody been through the Lien Recovery Fund Act? Yeah, not fun, is it? You probably were asking yourself in the middle or towards the end why you ever even made a claim on it. It can be good sometimes, but it can be very frustrating and difficult. What the fund does, it provides homeowners with protection against mechanics liens if they've paid in full, okay? It creates a fund of last resort to pay contractors and suppliers who are prevented from recovering through the mechanics lien process, provided that they've complied with all the preliminary notice requirements.
Why would somebody be prevented from collecting?
Prevented from collecting, so what basically, because the fund doesn't allow you to collect against a homeowner, and we'll talk about that, who's paid a general in full, and the general for some reason hasn't passed on that money to the sub. So it's protecting the homeowner, but then it recognizes, hey, we need to protect the subcontractor too, because the subcontractor may have done nothing wrong and hasn't gotten paid, so who's going to pay? Fund, theoretically, is going to pay. What the fund does not do, it does not protect or apply to a homeowner who does not pay a contractor with whom they contract directly. So if the homeowner has not paid the general direct for all the money what it's worth, for the money that the general contractor is due, the homeowner cannot claim relief under the Utah Recovery Fund Act. Okay? It does not assist contractors or suppliers in collecting accounts receivable from homeowners or other entities initially. You got to exhaust other options first. You got to, if you're a sub, the general is your money, you got to sue your general and get a judgment against them and then take it to the lien recovery fund. It does not reimburse homeowners who pay mechanics liens for any reason. So if a homeowner in that first situation has paid $500,000 to the general has paid all his subs except for one, the sub puts a lien on the house, and the homeowner goes ahead and pays it twice, basically pays the sub and pays it twice. The homeowner then can't go to the fund and try and get reimbursement for that money. It does not apply to multifamily residential or commercial projects. It's just single family dwellings. This is how it protects homeowners. To be protected by the act, a homeowner must have a written contract. Can't be an oral contract. It's got to be a written contract with a licensed contractor. Okay? If a homeowner contracts with somebody who's not licensed, they're not going to have protection under the fund. It must be a single family or duplex residence. The homeowner has to pay their general in full, and the homeowner must occupy the residence as a primary or secondary residence within 180 days of construction. So it does not apply to spec homes that are left unoccupied for more than 180 days. It provides a fund of last resort. This is what you as a contractor must do if you're seeking relief under the fund. You must provide qualified services. What qualified services are basically construction work that we talked about in the beginning. If you've improved the property through services that you provided, that's a qualified service. You got to pay the required fee. So in order, as you're aware, in order to become licensed in Utah, you have to opt in and pay the required fee for the fund. It's just basically a pool that everybody pays into, creating a slush fund for these types of situations. I believe right now it's $325. Okay? Does not give you a right to recover. You still must follow very specific requirements that we're going to talk about. You have to be currently licensed. So if you've let your license lapse, say you're licensed when you perform the work, and then by the time you bring the claim, you're not licensed, you're not going to be able to bring the claim. You've got to keep that current on your license. And you got to fulfill certain requirements. You got to notify the homeowner of your claim, do a certificate of compliance, get a judgment against the general. You have to attempt to execute judgment on the general. So if you get a judgment, you have to actually make attempts to collect. Some other details, you can recover interest on any unpaid balance up to 10%. That's 10% per year. So whatever the principal amount you're owed, you get 10% on top of that per annum. Attorney's fees up to 15% of qualified services. If more than $75,000 was unpaid on a project, then claimants share pro rata. So if you got a project where you have multiple subs making claims on the fund, and it is more than $75,000, and the claimants are owed more than a combined $75,000, and they're going to have to share on a pro rata basis. They're not going to pay, more than the 75. Okay, so takeaway from the lien fund: if you're not paid, there's recourse. What you can do to help keep your rights under the lien fund: keep your license current, always perform written contracts, and preserve your lien rights by filing your preliminary notices. Talked about the deadlines for preliminary notice and some of the basics. Okay, so that's the end of our lien presentation.
Raise your hand again if you didn't get a handout. So, okay, they're coming down.
Jeffrey Orr? Yeah. We need you for a minute. And you needed the book, right? So, you needed the book. Okay, I need you for 1 second. I'll grab you a book.
I think one's coming your way, sir. Okay, my name is, did you get one?
I just need a book.
Oh, okay, I don't do books. Okay.
Run through this quiz before we start on contracts. This just kind of recaps some of the stuff we covered on mechanics lien, but number one, a mechanics lien gives the lien holder A, the right to be paid only if the property is sold; B, the ability to force the property into foreclosure; C, a payment guarantee for qualifying work; D, both A and C. And have any brave souls?
Let's say B.
So B as in boy?
Yeah.
That's right. That's right. Okay. So the reason being, if you have a mechanics lien, A is not right because a property doesn't have to be sold in order for you to get paid on your mechanics lien. Conversely, what usually happens is you file a mechanics lien and eventually you're going to get paid without having to foreclose and sell the property. C is incorrect because there's no guarantee that you're going to get paid for your work just because you file a mechanics lien. I've seen lots of mechanics liens that fail. A lot of times, mechanics lien is filed because there's a difference in opinion as to whether the work was completed in a non-defective manner or timely. Sometimes the owner or general hasn't paid you because there's an issue with your work. You might not think there is, but there's a bona fide dispute, and sometimes you might lose on that. Okay. Number two, general contractors and subcontractors have lien rights, but material suppliers do not have lien rights. True or false? It's false. Good news for you suppliers. If you're a supplier, though, make sure you keep track of where your supplies are going. I mean, because most of the time you're shipping them somewhere, all right? And you may be shipping them to a client that does a lot of business with you. And if you don't know where those supplies are going, how are you going to prove which supplies went where? So make sure as a supplier, you keep track of where your supplies are going and when, so that if you have to file a lien, you can track where those supplies went and how much you're owed for those supplies. I've seen cases where a material supplier has done, doing a ton of work for a general contractor and sending materials all over the place, but at the end of the day, they haven't kept adequate track or support where the supplies actually went. And if you can't track where they went and where they were used, then you can't prove your claim. Number three, the Utah State Construction Registry website is an optional forum that notifies parties of of contractors working on any given project. True or false? That's true. It is optional. You don't have to do it. I recommend you do it, but you don't have to. Number 4, the SCR is intended to be used only by contractors. False. As we saw, various people and entities use the SCR, banks, owners, suppliers. Number 5, basically I'll just ask, are all of the following that are in number 5 considered construction work, giving rights for lien services? Yes, I would say so. Like I said, construction work is defined very broadly in Utah. Okay, number 6, Utah law allows for mechanics liens to be filed against public projects. True or false? False. What's filed against public projects? Bonds. Number 7, to preserve mechanics liens rights, a claimant must file a preliminary notice on the SCR within how many days of its first work? 20 days. If you are a general contractor on a private project, residential or commercial, you must file a notice of commencement on the SCR. True or false? False. Notices commencement aren't even an option anymore on private projects. They are only an option and a requirement on public projects. Number 9, a property's physical address is sufficient to identify it for purposes of filing a notice on the SCR. True or false? False. Number 10, a mechanics lien must be filed with the county recorder's office within how many days after final completion of the work? 90 days if a notice of completion, and if no notice of completion, 180. Number 11, Utah's lien recovery fund protects homeowners from subcontractors' liens even if they don't pay the general contractor in full. True or false? That's false. Homeowner has to pay the general contractor in full. Number 12, a contractor is not required to be licensed to become a member of the lien recovery fund. True or false? It's false. All right. Oh, correct. There's actually 2 correct answers, right? It depends. It depends. I think, as a matter for your purposes, I would say you can circle both. But I would say, for your business practices, do 90. I mean, if you haven't been paid within 90 days after a project's been completed, something's really wrong, and you should just file your lien within the 90 days. Okay, let's talk about any questions about mechanics liens. It's a really boring subject, but it's kind of important. So it's gonna. Let's talk about contracts, which also is not very exciting, but I have some important things to say about contracts, and hopefully you get something out of it. So most important thing about a contract is, in my opinion, is to read it. I mean, how many times in your lives have you had a contract in front of you and you don't read it and you sign it? I'm not just talking about in the contracting field. I'm talking about whether a hospital and you're asked to sign a release or something, or other contracts, an insurance policy. I have not read every contract that I've signed, and that's probably not the smartest thing to do, because what happens when you sign a contract? You're making certain promises. You are undertaking obligations and duties that you are going to be held legally responsible for, and they can have dire consequences if you don't do them. That's why it's so important to read your contracts, not just your contracting contracts, but all contracts, and hopefully I can do a better job of that. But yeah, when you sign your name to something, to a legal document, that's serious business, and you should know what you're signing to. Contract basics, okay? Must a contract be in writing to be enforceable? No. You can have oral contracts. Probably all of you have had an oral contract here one time or another, handshake deal. Would I recommend oral contracts? No. No, I would not. Why? What happens when you have an oral contract and it comes down to proving what's in the contract? You can't prove it. It's other than your testimony versus somebody else's testimony, and if there's no documentary evidence to back it up, the judge is going to have to make a judgment call on who he believes. They can be contracts. Is a written contract valid only if both parties sign? What do you think? Do both parties have to sign a contract? Hey, when I went to law school, I was surprised when I heard that. No, not necessarily. Only the party to be charged must actually sign. However, typically in a contract, both parties are taking on responsibilities and duties, and so they both have to sign it. So I would, maybe I should just take this out of the presentation, but I would say, you should be signing your contracts in addition to the other person as well, because while it's not legally required, if you don't have anything under the contract to be responsible for, you should sign it. My recommendation, always have a written, negotiated, and signed by both parties contract before starting work. If the scope of work is fuzzy before you start your contract or before you start work, you gotta be careful about that. Before you start work, you wanna know what your scope of work is, what the timing of the work is, how much you're gonna get paid. You gotta know that stuff. Read what you sign, detail the negotiated scope of work. Make sure, I can't tell you how many contract disputes are over a disagreement in what the scope of work actually is. Make sure you're very clear in your contracts what you're going to do or what you want the other party to do, including how they're going to be paid. Is it going to be lump sum, unit price, cost plus? What's included and excluded? That's very important. I think it's very important. Some of the better contracts I see are people that include having the inclusions, but also exclusions as well. You have to determine whether you want an attorney fee and interest provision. In Utah, you cannot get attorney's fees for a breach of contract claim unless there's a provision in your contract that says the prevailing party is entitled to attorney's fees. If a contract is silent as to whether you get attorney's fees or not, you're not going to get your attorney's fees if you win. You're going to have to pay your own attorney's fees. It's a double-edged sword, because what if you have one in your contract and you lose? You're going to be responsible for the other sides. So that's a business decision you have to make. If you feel that you run a tip-top ship and you're very careful and you're following your contracts to the T and you're treating people with fairness and trying not to get over on anybody, I recommend an attorney fee provision. Limitation of liability clause. You can actually limit the amount of your liability in your contracts. If a party agrees that you're only responsible for a certain amount, even if it's less than the contract amount, if you do something wrong, the law is going to uphold that. You can have a limitation of liability. So, for example, if you have a contract for $500,000 of work and you have a limitation of liability clause that states that in case I breach the contract, I will not be responsible for more than $50,000 or whatever, typically the law will enforce that. More complex or higher dollar value agreements should be reviewed by an attorney. I think some of my more sophisticated and smart clients, they will have us review contracts that they have questions with. Most of the time, you don't need an attorney probably to review a contract. But if you're reading a contract and you're not understanding what some of the provisions mean, and you have questions as to them, it's not a bad idea to have your attorney look at that and explain to you what it means and whether you should try and negotiate that out. Because at the end of the day, you're taking on the risk of whatever it means. Contract basics, 8 things to consider when you enter into a contract. Who are you contracting with? Time frame of when the work's supposed to begin and end. Price, payment, and payment policies. Important terms like liquidated damages, flow down clauses, warranty work, retainage, contingent payment clauses, how change orders will be handled, dispute resolution, indemnity, and lien waivers. So this is basically what we're going to talk about today, these 8 contract basics, what to look for in your contracts, what they mean. First off, who are you dealing with? You gotta know who your contracting party is. You gotta know if they're reputable in the field. If you know people who have worked for an owner or a general that you're going to be working for and you don't know anything about them, you should ask around. You should ask to see if they're a reputable person, if they pay their bills on time, if they're good to work with and for. Because if you get in a project and you have a nightmare owner or general contractor, it's going to make your life miserable. And so you got to know who you're dealing with. How do you do that? Well, first you want to know who you're contracting with. Is it an individual or a business entity, corporation, partnership, limited liability company, sole proprietor, shell company? Because maybe you're contracting with an owner that's well-heeled, has a lot of money, but if you're not contracting with that individual, but rather a corporation or limited liability company of that person. At the end of the day, if something goes wrong and you're looking for payment, you're not going to be able to sue him individually because your contract is not with the individual. Your contract's with the corporation or limited liability company or partnership. And that's why people form corporations, so they limit their personal liability. So you have to know if you're contracting with somebody other than the individual, you want to know what their background is, if they've done work for other people, if they're reputable, if they have money to fund the project. Know the financial status or entity of the entity or person. So the AIA allows a contractor to request financial information before work commences. You should request financial information and make sure there's a construction loan in place or financing in place that's going to be adequate to fund the project. That's common sense. Those are some examples of financial verification: loan commitment, government appropriation, whatever. You may want to consider whether you want to try and get a personal guarantee from the person who's supposed to pay for the work. Yeah.
Sorry, question.
Yeah, you
What's
bet.
the significance of the AIA allowing?
Well, the AIA has a specific provision in their contract, actually.
So if you're using that contract.
If you're using that contract, yeah.
Right.
Yeah, like it's like written in the AIA contract where it allows the contracting party to actually request financial information before the work commences. Now, what if a contract doesn't have that? Can you still request financial information? You can. Is the other side legally required to provide it to you? Well, no, not necessarily, because the contract doesn't say it. Doesn't mean you can't request it, but the thing about the AIA contract is it legally requires the party to furnish it. And if you don't have an AIA contract, it's a different form of contract. If you've got an owner who's not willing to give you information about the financing of the project, well, then you may be dealing with somebody like that.
Can I ask you a question?
Yeah.
So somebody reads contracts anyways, could you put in that only one party can get attorney's fees?
That's a good question. That's how they used to do it. So yeah, so the question is, if in a contract, can you have a one-sided attorney fee provision? So if it's your contract and you say, hey, listen, in any dispute, if I prevail, I get attorney's fees, but you don't get attorney's fees. Utah law, that's an illegal provision now. Yeah, it's illegal. So, and if there is one in there, what the courts do is they will enforce it both ways. So they'll just say, okay, yeah, that's fine, you get attorney's fees, but if they win, they get attorney's fees against you. They used to allow that. Yeah. And I think they still do in some states, but not in Utah. Time frame. You want to read your contract and make sure you understand your state, the date to start work, whether it's phased work, whether you're dealing with other subcontractor work, what the schedule is, what defines completion. Like we talked about before, is a permanent certificate of occupancy required? A final inspection, no substantial work left to be performed. You want to understand, because that's important, because you don't want to get a delay claim against you later on when you've performed basically all the work, but the contract defines all the work separately. So if the contract defines substantial completion as all work completed, including minor punch list items, that's going to be the substantial completion date for purposes of the contract, and you may be left with having a late project completed because there's just a few minor punch list items left to be performed. Provisions for delay, which are dealt through change orders, we'll talk about. You want to give some consideration on how the price is to be determined. That can be dependent on the project, as you're aware. If you want a lump sum, where you have a ceiling, and this is all my costs are involved in this. This is how much I'll do it for. If you want to do unit prices, like if you're removing material from a river or a canal and it's based on unit weight or something, you probably want a unit price contract. Cost plus, the cost of actual construction plus whatever overhead and profit you want to charge. So give some consideration. Think of what pricing you want to use. You might want to use the same for all your projects, or it might depend on the project. What's included and excluded in the price, percentage complete, at which phase, so basically how you're getting paid. You're going to want to understand payment procedures in your contract, when you get paid. define expectations on when payment will be received, 30, 60, 90 days. Typically in a construction contract, 30 days is typical from the time the invoice is received. 60, 90 days, that's a long time not to get paid. But as we'll see later on, government, they typically have like 90 days to pay you. The bottom line is you want to upfront agree on the process. You don't want to have a situation where you haven't read your contract on the payment provisions and you submit your first invoice and you're expecting to get paid within a couple of weeks, but your contract says 60 days and you're going to be tied to that if your contract says 60 days. Let's talk about some prompt payment acts in Utah. So, and this is if there's no payment provision in the contract as to time of when to get paid. Basically, what Utah law says is contractors must pay their subcontractors within 30 days of receiving payment from the owner or from the higher up. If a contractor does not make payment, the contractor must pay interest at 12% per annum and attorney's fees and costs. So this is an actual law, and I'm sure most, if not all of you, have gone more than 30 days without receiving payment from a contractor that received payment, well before that. Technically, if a contractor is holding money for more than 30 days of receiving payment from the owner, that's illegal, unless your contract allows him to do that. I mean, you have to read your contract. If they have a 60-day payment provision, then he could probably do that. But if there is no payment provision, or the payment provision says 30 days, then he's got 30 days. And if he doesn't do it, you could actually take him to court and get interest and attorney's fees. But typically, in practice, do you really see that? Do you really want to do that? You don't really see that a lot, because if you get paid on day 40, do you really want to go to court over 10 days late, interest and stuff like that? Do you really want? Probably not. But legally, you could. Utah's Public Prompt Payment Act, the state must pay you by the date specified in your contract or within 60 days after receipt of notice. Okay? So the state typically, unless the contract says something different, the state has 60 days after it receives your invoice. So you could be 90 days out from payment on a public job. Say you do work at the beginning of the month, you don't invoice it until the end of the month. You're already 30 days past your work point. At that point, at that 30 days, the state will have 60 days to pay you. So you're going to be 90 days out. So if you are working on a state project, you want to maybe do your invoices more regularly so that you can kind of cut their time off and maybe get paid before that 90 days. Yeah.
Would this supersede any AIA contract or anything you have specifically with your subcontractor?
Yeah, I mean, if you agree, if in your contract you agree to different payment provisions, like timing of payment, then yeah, those should supersede this. Okay? Because the law is going to allow you to contract typically for what you want to contract for, unless it's something egregious and illegal. And there are some that the law does not recognize, but this isn't one of them. Okay, we talked about attorney's fees in contracts. Typically, each party is responsible for their own attorney's fees unless there's a statute allowing for attorney's fees, which typically in construction contracts, there's no statute allowing for attorney's fees other than mechanics liens, but that's not your contract. Mechanics liens gives it, or like I said before, if your contract provides for attorney's fees. This is language of a typical attorney fee provision in the contract. Quote, the prevailing party in any lawsuit arising from this agreement will be entitled to an award of attorney's fees and costs incurred in that lawsuit. That's the type of language you would need to have in your contract if you want to get attorney's fees if you win your case. Interest. Okay. What about interest? If your contract is silent about interest, whereas when I mean by silent, if it doesn't say anything about interest, do you think you're entitled to get interest if you ultimately get paid late and prevail? You are, actually. If the contract is silent, there's a statute in Utah that provides for 10% per annum interest on whatever you're owed. Okay? Can you do lower and higher than that in a contract? Yes. If you have a contract and you decide 5% per annum, the law will recognize that and won't enforce the 10%. If you have one for 18% per annum, The law will recognize that. What about 36%? Do you think the law will recognize that? In Utah? In Utah, I've seen it, 36%. I've never seen anything higher than 36%. But typically, the courts will enforce an interest provision that you agree to. So in reviewing your contracts, you're going to want to see whether there's an attorney fee provision and an interest provision. If there's no interest provision, it's 10%. If there is an interest provision, whatever you agree to, you're going to be, responsible for if at the end of the day you lose. Unless it's more than 36%, you might have a claim.
From the date of when you get a judgment?
It's from the date, nope, it's from the date the amount was due. So like, because a lawsuit you can tie you up for years. So if you were due that amount, in March of 2015, then you have to file a lawsuit and you don't get the judgment until March of 2016 or 2017. Interest goes back to March of 2015, okay? Not 2016 or 17. Oh yeah, this is interesting. So if you have an interest and attorney fee provision on an invoice, not a contract, an invoice, you know how sometimes you invoice somebody and you've probably seen it on invoices that maybe you have or received, and at the bottom it says any uncollected amounts are subject to an 18% interest and attorney's fees to collect. That is not enforceable because an invoice is not a contract. Okay, an invoice is a one-sided document that you are sending to somebody for work that you performed under a contract, but the invoice is not a contract. So if you want an attorney fee provision and an interest provision, put it in your contract up front. By statute, the amount of interest can be any agreed upon percentage, probably bound to what is reasonable, typically 18%. If not specified, the statute defines it 10%, like we just talked about. Okay, liquidated damages, what are they? They're predetermined damages, like money, that are paid if a party fails to perform as promised. So you've seen this in contracts that, hey, if you don't finish on time, you're subject to a $500 per day liquidated damage provision. Or liquidated damages. That's a liquidated damage provision. And say you finish the job 10 days late, that's $5,000. Say the actual damages that the owner incurred were only like $2,000 or didn't incur any damages. Can the owner still get the liquidated damages? Yes, you agreed to it up front as in the contract, and you will be responsible for it if you're found to have delayed the project. So liquidated damages, they must be a reasonable forecast of damages, and typically why owners put them in contracts is because they're thinking they don't know what their damages are going to be if the project is late, untimely. So they tried, but they're supposed to try and do a reasonable forecast. For example, if you're performing work on a 7-Eleven and you don't, because of your untimely work, the 7-Eleven opens up a month late. Well, the contractor, or I'm sorry, the owner, before that all happens, if they want a liquidated damage provision, they're supposed to try and reasonably calculate or estimate what their damages might be in terms of lost profits, lost opportunities, if the 7-Eleven is not completed on time. They can't just take a number out of the air and say $100,000 a day. That's not reasonable. They have to try and give a reasonable forecast of it. But it doesn't have to be precise. It doesn't have to be, it just has to be, they have to put forth some effort and have some basis how they arrived at that number. Cannot be a penalty, but recent Utah cases seem more willing to uphold liquidated damages, even if they're for kind of higher amounts than what most people would agree to. So if you're agreeing to a liquidated damage provision, be careful, because most likely the court's going to hold you to that, even if it's maybe a little bit overboard, because typically judges and courts, they aren't going to rewrite your contract. If you agree to something in your contract, they're typically going to hold you to it. So, and that includes liquidated damages, unless it's like really unreasonable. But you don't want to take that risk. You want to make sure you feel comfortable with a liquidated damage provision up front and say, okay, that makes sense for this type of project. Can an owner claim liquidated damages and actual damages? Rather, can an owner double dip? Can they put a liquidated damage provision in their contract and say, I get $500 a day for any day that we're past, the project deadline, and I also get any actual damages that I'm able to prove because of your untimely work or defective work. You think an owner can do that? That's called double dipping. No, an owner has to pick. An owner can pick whether to enforce the liquidated damage or actual damage clause if the contract gives them that right. The owner cannot get both. Liquidated damages, they should cease upon substantial completion of the project, not final completion. So substantial completion, that typically, if the building is ready for occupancy, but there's still some minor items, the law is going to recognize that liquidated damages are cut off at substantial completion, not final.
Even if you don't have that word in there?
Even if you don't have that word in there. Flow down clause. Okay, flow down clause is a provision in a subcontract that incorporates the terms of the general contractor's contract with the owner. Example is, subcontractor is bound to the general contractor to the same extent that the general contractor is bound to the owner under the general contractor's agreement with the owner. If I'm a general contractor, I want that in there with all my contracts with the subcontractor, because you want your subcontractors to be on board with whatever duties and obligations that they have for your work to the owner. Conversely, if you are a subcontractor, if you see one of those provisions that's obligating you to the owner to the same extent the general contractor is obligated to the owner, what does that tell you as a subcontractor? What do you need to do? You need to go get a copy of the prime contract and see what duties and responsibilities the general contractor has as the owner, and make sure that you feel comfortable and it's on the same page and within your scope. Warranty. Utah law requires a 1-year warranty for construction. That's typically what you see in contracts, is a 1-year warranty. Sometimes in contracts you may see a longer period of warranty. If you see that, that's something that I would try to, if I were you, I'd try to negotiate out and say Utah law only requires a 1, because if you agree to a 2 or 3 year warranty, then the courts will enforce that. What this is saying is that if there is no warranty provision, then the fallback is the 1-year warranty. You must define in the contract what, if any, warranty that you will provide is typically 1 year. So I think I just misspoke, actually. If it's not in the contract, there is no actual warranty. That doesn't mean you can't be sued. That just means that you will have no real duty to come back within that year and fix any warranty work, but that doesn't mean you can't be sued for defective work. If I were you, I'd do a 1-year warranty in your contract, which gives you, because what that does is, if there's something wrong with your work, and then you want some control over that. You don't want an owner to just haul off and file a lawsuit against you, or go and hire somebody else to fix your work and incur a bunch more money. If there's something wrong with your work, you want the right to come back and kind of look at it and say, hey, look, yeah, okay, there's some issues with it. I can control that. I can control the cost and how it's done. It does. A warranty protects yourself and gives you the right to come back within that 1 year if something goes wrong. Retention. Okay, what's retention? Everybody knows what retention is. It's a percentage of the agreed upon contract prices withheld until the work is complete to ensure the subcontractor will satisfy its obligations. Okay. It's limited to a maximum of 5% by law in Utah for private projects. Okay. Doesn't apply to residential projects. Applies to commercial projects, multifamily unit projects, stuff like that. But if you are doing a commercial project in Utah that's not federally funded, then the most somebody can retain against you is 5%. Okay? If you see a 10% retention, that's illegal, it's not enforceable. The court will only recognize 5%. Must be held, this 5% must be held in an interest-bearing account, and the subcontractor is entitled to the interest. Who here, subs or generals, who here has ever seen interest on the retention that's being withheld from them for months and months? Yeah, I don't see any hands. You're legally entitled to it. Next time somebody withholds retention from you, and if they cut you a check for 5%, say, what about the interest? You're legally entitled to it. Because there's a reason why it's being retained. Well, it's not. There's a good reason. Okay, the good reason is it's protecting the owner. Okay, to ensure that the project is completed and that you do your work, because you have that carrot at the end, the 5%. But that's legitimate. What's not legitimate are owners withholding 5% and investing it and making money off it and just paying you the 5% at the end. That's kind of unethical. That's illegal, actually. If you really want to hold their feet to the fire, you can file a lawsuit against them and try to get interest. Is it practical? I mean, at the end of the day, probably not practical, but you're entitled to it. And you should give some thought as to, next time you get retention is, kindly request the interest and say that that's the law, that I'm entitled to the interest. So I don't think I've ever seen a subcontractor get that voluntarily, but you're entitled to it. Penalties for wrongful retention. So if an owner withholds more than 5% or withholds the 5% past the time that it's due, when's it due? Final completion. The penalties are 2% per month on whatever's owed, plus any additional interest under the contract, or if you don't have an interest provision in the contract, 10% per annum. You also can get attorney fees and costs for the prevailing party. So there's some serious, if you really want to press it against us, and where you see this, though, is typically, this isn't going to become a dispute unless the subcontractor is owed something more than retention. So if you have a big dispute with an owner or a general and there's a lot of money at stake and you're not getting paid that plus your retention, and because they have issues with your work or whatever, and you disagree and say, no, it's fine, that's where where you'll see the wrongful retention argument come more into play, because you're not just dealing with that small, interest on the 5% and the 5% of the contract amount. You're dealing with something more, and that's something that, an attorney will throw in as a claim to strengthen the position. Yeah.
And is that something if it's written in the contract, then it can be graded like 10% of the pay?
If the 10% interest? Okay, yeah, if the 10% is written into the contract, that's unenforceable. I mean, you can go back, and if I were you, I would go back to whoever's requesting the 10%, because it might be somebody who's from out of town, or it might be somebody who not familiar with the retention statute. Just explain nicely, hey, listen, you're only allowed by Utah law to retain 5%, and usually they'll change it, because usually they just weren't aware of it or whatever, and they're like, okay, yeah, that's fine, we'll do the 5%.
When does the interest on the retainage start?
At the time it's due. So if the time it's due would be at final completion. So at that point, that's when the interest starts. Oh, I'm sorry. Are you talking about? You're talking about the interest-bearing account. Yeah, no, okay. Yeah, I thought you were talking about like general interest on the amount. So for the interest-bearing account, they're supposed to be putting that in an interest-bearing account immediately. So as they're retaining it, so you're entitled to any interest. Now, what the problem is, the law doesn't say where they're supposed to hold it and how much interest they're supposed to try and get. It just says put it in an interest-bearing account. Most people will put it in like a bank account that has a very low interest rate, and that technically is legal. They don't have to invest in like high yield stocks or whatever like that. Although I'll tell you, some owners I think do. I think it's part of cash flow and stuff like that. But you're entitled to whatever interest is incurred on that. Okay, contingent payment clauses. These are important. Are they enforceable? Yes, well, probably. The reason why, well, probably, and we'll talk about it, is there's no Utah Supreme Court case or Utah Court of Appeals case that has analyzed these contingent payment clauses that we're going to talk about. But trial courts have taken a look at them, and what we're seeing is most judges are finding them enforceable. So there's two contingent payment clauses that you'll see in a contract. One is sometimes you'll see a paid when paid clause, and what that is, there's no shift of risk of payment. So there's no shift of risk from the general contractor to the sub. Let's talk about it. So a sample provision of a paid when paid is prime contractor will pay a subcontractor within 10 days of receipt of payment from owner. Again, there's no Utah law on this. So if I'm a general and I put this in my contract, at first glance you would think that excuses you from paying your subcontractor if you don't get paid by the owner. I mean, look at the language. Prime contractor will pay subcontractor within 10 days of receiving payment from the owner. Well, what if the owner never pays you? Then, this language, it seems to infer or imply that you have no responsibility to pay the subcontractor, right? Wrong, okay? Because there's no specific language shifting the risk of payment. So if you're a general contractor and you have a provision like that in your contract where it says, hey, I'll pay you when I get paid, that's not going to get you off the hook eventually. That will buy you some time, but if the owner never pays you, you're still probably going to be responsible for paying your subcontractor with that type of provision, okay? Here's the reason why. The courts are looking for more of a paid if paid clause. So a paid if paid clause is very clear that you as the general are shifting the risk of payment from you to the owner, okay, and to the subcontractor. And you've got to have some very clear and unambiguous language in your contract in order for you as a general or a subcontractor with lower tier subs to take advantage of that. Sample provision. General contractor will pay subcontractor only if owner pays general contractor. See, that's different from this. There's no only if. It just says, I'll pay you when I get paid. The laws are probably not going to recognize that as a shift in payment or shift in risk. The law is probably going to recognize language like this: I will only pay you if I get paid by the owner. And if I don't get paid by the owner, then I'm not responsible to pay you. So if I'm a general, I'm putting that in my contract. I'm putting something like that. And I usually see it, we're seeing it more and more often in contracts with generals and subs, and where it says, hey, listen, subcontractor, I'm not going to pay you unless I get paid. And you understand that you are relying on the financial capabilities of the owner, and if the owner doesn't pay me, then I'm under no legal obligation to pay you. That will probably get you, general contractor, off the hook with a sub for an owner that fails to pay. As a sub, it's tough to try and negotiate that out because you're seeing it in more and more contracts. So, I mean, you have to make the decision, hey, if you see that in one of your contracts, do you really want the work? Because if you're not going to agree to that provision, chances are the general will go find somebody else who will agree to it. But that doesn't mean you're totally up the creek. That just makes your mechanic liens and bond liens rights more important. Because if you have that provision in your contract and the owner doesn't pay the general, then you may lose out on your ability to file a lawsuit against the general for breach of contract. But what do you have? You have a lien claim against the owner, hopefully, only if you've followed the preliminary notice and lien laws. But if you see that provision in your contract, make sure you read it and determine whether it's a paid when paid or paid if paid, and whether you're comfortable with proceeding along with that. If it's a paid if paid, especially, you're going to want to make sure you do a little research on the owner and make sure that they're reputable and somebody good to work with and who typically pays their bills. Funny thing about the paid if paid, they're not enforceable in a lot of states. We think they will be in Utah if it ever goes up on the Court of Appeals or Supreme Court, because we're seeing it enforced at trial court levels. Any questions on the contingent payment clauses? Okay, change orders. This is great. So you got the original contract is a small raft, and the change order is a big yacht. I sure projects, most projects, they end up having change orders. Hopefully it's not this bad, but that's why it's so important to come to terms up front about what the scope of work is in your contract, so that you don't have disagreements, or you can limit your disagreements on what's a change order later on. But always, I mean, there's probably going to be change orders because owners change their mind or stuff comes up, unforeseen conditions that require changes to your contract. So let's talk about change orders and what you should do. Must change orders be agreed to in writing in Utah? What do you think? It depends. Okay. No, unless the contract says so. So that, when you get your contract, make sure you pay special attention to the change order procedure of your contract. If your contract requires you to have a written change order in order for it to be valid, then you should follow the written change order procedure. If you don't, chances are you're going to lose out on your change order rights if the owner later, or the general contractor later, challenges you on it. So in your contracts, make sure you define the process of change orders in your contract, follow your change orders, make sure everything is documented. This can be somewhat difficult when you're on a project because a lot of change orders obviously arise when you're in the field and you're doing work and an owner or a general says, hey, look, we need to do this. And you're thinking, boy, that's a change in scope of work in my contract. And you may have some sort of oral agreement with them that, yeah, it's a change. We'll figure it out later. You got to be careful with that. I mean, if that's the case and the work has to be done right then, you want to document it as well as you can right then and try and get a written change order right there. It doesn't have to be on any kind of special form. It can be, you can get out a piece of paper and say, here's this change in the work. We agree to this change. This is about how much it's going to cost. We have to determine pricing later, but we agree there's a change, and this is probably how much time it's going to affect us, that it's going to take. You want to come up with a basic understanding of what the change order encompasses in terms of the scope of work change, the pricing of the change order, and the timing that the work is going to be performed. Okay. What if you have a change order that you don't get in writing, though? I mean, not all is necessarily lost. I mean, it's a tough hurdle to overcome if your contract has a written change order provision and you're not following it. But if you can establish that in the project that there's a course of conduct between you and the other party of oral change orders and that they've been honored by both sides, then the law is probably is most likely going to acknowledge that and say they're okay. But those are the things you have to prove in order to prove a oral change order. You're going to have to show that there's a prolonged failure to make changes in writing in the scope of work. You're going to have to show that the owner requested the work and that you expected to receive payment for the work and that the owner knew that you expected to be paid for the work. So if you can't do some big elaborate change order on site, make sure you document it by emails, texts, whatever, and you have an acknowledgement, a meeting of the minds back and forth that what you've got there is a change, and there's going to be a change in price, and it's going to be approximately somewhere in this neighborhood, and it's going to affect the timing of the work by X amount. Any question on that?
Can any of these changes to any of the contracts be audio visual, i.e. phone?
Oh yeah.
Recorded?
Yeah, absolutely.
That's valid.
Absolutely. Any documentation, whether it's written or audio or whatever, is good. I'd say the more documentation or whatever, recording, whatever, that's a good thing because that's evidence, and it's not just a he said, she said at that point. If you have an owner on tape, agreeing to a change order right there, well, that's dynamite evidence that you have. You can hopefully don't have to go to court over, but you can say, hey, look, we had this agreement, and I don't remember that. It's like, hey, well, yeah, don't you remember? I recorded it. Here it is. Tough to overcome if you're the other
Both
party.
sides should agree that they should know that customer should know that you are recording the conversation.
I think that's good business. The question is, if you're going to record somebody, especially a client, you should let them know, hey, you mind if I'm just going to record this just so we have a good record of it. Yeah, you should do that. That's good business practice. Legally, do you have to do that? No. Okay, police is off, like government officials, police officers, people like that, they have to do that if they're, they have to tell you that they're recording you basically. Private parties, you can record without the other's knowledge and use it against them later on. You can do that. It's not illegal, but I think good business practice is, hey, listen, we need to make sure we get an understanding about this, and so I'm going to record it. I don't have a pen right now. I have my phone. Let's record it. Get it down on. Say yes. This is March 15th, 2015. So and so is here. I'm here. This is what we've agreed to. There's been a scope change. This is what the scope change is. Price, timing, stuff like that. Okay. Anything else on change orders? All right. Dispute resolution. What's the best way to avoid and resolve disputes? Because really the last thing that you guys need in your lives is to spend a lot of time and money over resolving disputes. I mean, your time is best utilized and you're most productive when you're creating things and building things and everything's going relatively smoothly. You don't want to spend a lot of time getting tied up in disputes and having to hire attorneys to help you get out of those disputes. That's not fun. So what's the best way to avoid and resolve disputes? Communication, okay? If you're having issues with your client or customer or the contractor, communicate those issues and disputes right up front. See if you can resolve those internally, because most disputes, I mean, you can probably resolve without it ever getting past the point of no return. Make sure and talk. If you can't get a resolved through communication, right there in the field or on the phone during the project or whatever, there's several things that you can do. Let's talk about negotiation. You can do this before you get an attorney involved or whatever. You can try to negotiate. You can sit down with the business people of the people you're dealing with and your business people and try and hammer out, maybe an understanding without having to go to litigation, whatever. I think communication, negotiation right up front is always well worthwhile. I think most disputes can be handled that way. Some can't. Some you're just going to have a difference of opinion, and there's it's just too hard to overcome initially. You can do mediation. A lot of contracts have mandatory mediation clauses where before a party tries to take a matter to litigation or arbitration, you have to mediate it. Mediation is where both sides will, and you can do this with or without an attorney, but both sides will agree to hire a third-party neutral, so somebody experienced in the field of construction, to come help them maybe understand more about this dispute and try to come to a understanding and settlement of the dispute. Typically, a mediator is somebody who is a retired judge or an attorney who has experience in the construction industry. The role of a mediator is to meet with both parties. Okay, they typically sit down at the beginning with all parties in a room, do a meet and greet, get you've probably submitted some information to the mediator before, so the mediator has an idea what the dispute is and what both parties' positions are. The mediator kind of lets both parties maybe do an opening statement about their side of the story and strengths and weaknesses. Sometimes they do that. Sometimes they'll just break both parties off into separate rooms, and they'll go back and forth between the rooms and talk to the parties about strengths and weaknesses in their case. They'll talk about how they, as a third-party neutral, view their case, and what their opinion is if the case goes to trial eventually, what a judge might find or a jury might find. So they'll talk about certain strengths and weaknesses that you have, and they will talk to the other party about strengths and weaknesses they have. They'll also talk about other things that may not be related to the case in general, but maybe business relationships, if you want to preserve a business relationship. But the thing about a mediation is both sides come in with completely opposite expectations, and if you come in thinking you're going to get your high demand or your low dollar demand, it's just not going to happen. The nature of a mediation is the mediator is trying to get the parties to see the strengths and weaknesses in their case so that they become a little bit more realistic about the risks and where it might end up. And so it doesn't always end up in the middle of like a claim, but typically both sides have to give some in order for it to be successful. And if both parties are not willing to give some, then the mediation typically will not be successful. Mediations can occur at any time during the process. They can occur before a case is filed. They can occur at the beginning of the case. Typically, mediations that occur at the beginning of the case are not as successful in terms of settling it because a lot of the information is not known. A lot of times mediations occur in the middle of a lawsuit or towards the end of a lawsuit when pretty much both sides' cards have been laid on the table and people kind of know the strengths and weaknesses of the case, and the mediator has enough information to kind of give his or her opinion on how it's going, on how he thinks it's going to go at trial. Mediation is non-binding until if you come to an agreement at the mediation, the mediator will actually sit you down and type out an agreement, whatever you've agreed to. So if you have a claim and you've agreed to accept a certain amount, and the mediator will sit down, type out an agreement saying, so-and-so agrees to pay so-and-so this amount in exchange. All claims between the parties will be released and we're done. And if you sign that, that becomes a valid binding document, a contract. And if you have buyer's remorse the next day and you say, oh, gee, I wish I wouldn't have done that, I mean, that's too bad. You've agreed to it. That's a contract. The courts will enforce that. Any questions on mediation? Typically 1 day.
So would you recommend then that be part of this attorney thing? Can you have both things in there? If you pre-agree to submit to mediation.
Yep. Yep.
Plus the attorney fees clause in case you can't agree.
That's right. So in your contracts, you can decide how to resolve the dispute in any manner you want. So in your contract, you can have a clause that states, in the event of a dispute between the parties agree to meet for a minimum of 4 hours to try and negotiate the dispute before doing anything else. If negotiation is unsuccessful, the parties agree that before any litigation or arbitration, they will mediate the case, select an arbitrator mutually agreeable to each side, and they'll agree to do a 1-day mediation. You can do that, or you can do an arbitration clause where you say, in the event of a dispute, the parties agree to submit this matter to binding arbitration with AAA association, whatever, or abide by the arbitration procedures of Utah. So what arbitration?
They could never take it to court.
That's right. You can foreclose.
To
Yeah, that's right. So you can do that. You can prevent a party's ability to go to court by having a mandatory arbitration proceeding. Now, you cannot do a mandatory mediation proceeding and take away the ability to go to court. But you can choose between arbitration or litigation, because an arbitration is an actual judicial process. Mediation is not. And the reason why an arbitration is a judicial process is it's actually you are hiring a judge and an attorney or somebody experienced in the field of construction to take in evidence, hear testimony under oath, witness testimony, documentary evidence, hear arguments from attorneys. It's basically like a trial. And so an arbitration, at one point in time, people thought it's still pretty popular, especially in construction, because the good thing about an arbitration in construction is if you file a case with court, you don't get to choose your judge. And so in Utah, there's judges that are more experienced with construction than other judges, but you can't choose the judge. You can't say, okay, we're going to file this lawsuit and we're going to pick Judge so-and-so because he or she has a lot of experience in construction and we want them. No, you file your case and there's like a lottery where you basically get who they select, and it's a complete crapshoot. And so some judges know more about construction than others. Now, all our judges are bright, but some of them, they don't have the time to learn a ton about construction, and they may not understand some of the nuances. Whereas with arbitration, the parties can control who they select to be the finder of fact in their case. And so in arbitration, if you have that clause in your provision and say we're going to do arbitration, we're excluding litigation, we're going to do arbitration, then both sides will mutually agree to an arbitrator that they feel comfortable with. And it's typically a retired judge who knows a lot about construction, or an attorney, an experienced attorney who knows a lot about construction, who has no conflicts of interest, et cetera. And they take on evidence. It's an actual hearing. You come in, the attorney gives opening statements. There's direct and cross-examination. There's documents. The arbitrator is basically a judge. And at the end, after all the evidence is received, the arbitrator has 30 days to render a decision. The arbitrator will typically give a written decision and make a finding like a judge does. And that is legally binding. And in arbitration, there's no appeal from an arbitration unless there's serious misconduct or malfeasance on the part of the arbitrator. That's very difficult to find. So if you go to arbitration, you basically get one bite at the apple, which is good if you win and not, bad if you lose. Or sometimes it can be bad for both sides, because sometimes the arbitrator will maybe split the baby and you're not happy with that result and the other side's not happy with it, but that's it. You agreed to that process. There's no appeal right. Whereas litigation, there are appeal rights. If you're not happy with the decision that a judge or jury makes, you do have appeal rights to go to the Utah Court of Appeals and eventually to the Utah Supreme Court. The litigation process can take several years. For a typical construction case that's not overly complex, you're looking at least a year to a year and a half. To one that's maybe more complex, you're looking at 2 to 3 years, just the trial court. If you appeal it, that's another year to 2 years. So it can take some time, and that's something to consider when determining whether you want to escalate a dispute. And that's why I get back to negotiation and communication. If you can resolve your disputes without having to go to arbitration or litigation route, that's a good thing for you guys. I mean, it's good for my business if you get to litigation, but that's not good for you guys. I mean, you guys are best out making money in the field and creating things, but sometimes there's no option but to go litigation or arbitration to resolve the dispute because the gap is just too wide between the parties.
What's the difference in cost?
That's a good question. So what's the difference in cost between litigation and arbitration? So it used to be when arbitration was first starting out, and this is years ago, one of the purposes of arbitration was they would thought that it would be quicker and less expensive, okay? And the reason for that is that the rules of evidence and the amount of discovery that you're allowed to do in arbitration was supposed to be less than litigation. And there's supposed to be kind of an expedited track to where you could get to an arbitrator. Well, as the years have gone past, they've done studies, and while their arbitration typically is a little bit more cost-effective and less time-consuming, it's not as much as they once thought it would be. Arbitration has turned more into almost kind of quasi-litigation in terms of time and expense, but without the appeal rights. The trade-off on that is you get a real expert that hears your case and maybe understands it better than a judge. So while arbitration is still very popular in the construction field, it's become a little less so as these studies have come out. And it's not, the gap between the time and expense is not as great as they hoped it would be. Any other questions on dispute resolution? Okay, let's talk about indemnity. Indemnity is where one party is required to pay for the damages and legal expenses incurred by another party for claims related to the construction project. So you'll see in your contract sometimes an indemnity provision, which basically says, you agree to be responsible for any damages that occurred due to your fault or negligence or whatever, okay? Now, if an indemnity clause in your contract requires you to only be responsible for your mess-ups or your subcontractor's mess-ups, that's legal, that's valid, okay? That's common sense. If you mess up or if your subs mess up, then you should be responsible for it. What Utah does not recognize is if somebody is trying to get you to be responsible for somebody else's fault other than your own or your subcontractors, that's illegal. So if an owner is trying to get you to be responsible for any damages that occur on the project to third parties or whatever, and doesn't limit it to your fault or your subcontractor's fault, that's an illegal provision and it will not be enforced. And the basic reason behind that rationale is a good one, is we should only be responsible for our own mess-ups or for people who we're responsible for. So if you're a general, you are responsible for your subs, who are in turn responsible to you. But as to an owner, the owner's going to look to you because they contracted with you as the general. And the law doesn't want to make you responsible for the mess-ups of a third party or a subcontractor who you don't have any control over. And so that's kind of the reason behind that. Lien waivers. So typically owners and general contractors ask subcontractors to waive their lien rights for the portions of their work that subcontractors have been paid for. Okay. My advice to you, so if you're a general or an owner, as you're making payments, make sure you get lien waivers back, for that payment. You don't want to pay your subs, your generals or your subs, your suppliers until they've signed lien waivers. Okay. If they're not going to sign a lien waiver, don't pay them. Because if they sign the lien waivers, they can't now file liens anymore. Unless it's a conditional lien waiver that's just up to a specific amount of time. So you have conditional lien waivers or interim lien waivers. Those cover work up to a specific time. So during the project, you're going to want to get lien waivers as you are getting paid as the general and as you as the general are paying your subs and suppliers. Now, if you're a subcontractor being asked to sign lien waivers or don't sign them unless you're getting paid. Now, does that mean you have to get the money simultaneously as you're signing lien waiver? Ideally, yes, that's great. That's what you want. You want the check in hand. But sometimes you'll come up with, against owners or generals or whatever, that they will not even fund for you until they have the signed lien waiver in hand. So make sure if you have a lien waiver that they want you to sign before they pay you, make sure that the lien waiver is conditioned upon you receiving payment. So don't say that I so-and-so hereby acknowledge I've received X amount of dollars and waive all my lien rights and all claims against the property and sign your name. That could get you in trouble. Okay, yeah?
In reality, a lien waiver only works paper it's written on unless you have proof of payment.
Yeah. Yeah. I mean, what is that?
Yeah. Yeah.
Not my voice, I don't think. Maybe it was.
No. I mean, if you want to use that one as the one with the camera, you can, but you only need one of them to have the camera turned on and only one of them to have the audio turned on. Yeah.
Could be worse for that person. It's just fairly innocuous conversation. All right. Okay. So if you're being asked to sign a waiver, make sure you're getting paid for it. If you're not getting paid for it, then you can go back, basically and say, listen, I signed the lien waiver, but I never got paid for it. But you don't want to acknowledge in that lien waiver, hey, I have been paid, because then it becomes a he said, she said. You say, upon receipt of X amount of dollars, I hereby waive my lien rights. And there, when you receive that money, then that lien waiver becomes operative. But it does not become operative until you receive that money. But you got to be careful on how that lien waiver is crafted. Because what if you have owner or a general and you sign a lien waiver saying that you have been paid and you acknowledge it, and then later on you say, listen, I was never paid, and maybe there's an accounting mistake and the general thinks you've been paid, and they have this lien waiver saying, hey, I acknowledge I get paid, there's going to be problems. Waivers must be in a very specific form provided by statute or similar form, otherwise the waiver must be maybe invalid. Anyway, at the end of the job, you'll probably be asked to sign a lien waiver that is a full and final lien waiver of all rights. So make sure you don't sign one of those until you get paid, because at that point, if you sign one of those and you're not paid, then you're not going to have your lien rights anymore. So, any questions on any of the stuff we talked about today on contracts? Yeah.
Back on liquidated damages, is that the same as consequential damages?
Yeah, different. So consequential damages, so liquidated damages, they're determined up front. It's a specific amount. There's supposed to be a reasonable forecast of damages. The consequential damages are different. Those are damages that don't flow directly from the breach, but flow as a result of the breach. And I guess maybe the best example I can give you is consequential damages. Usually contractors don't have a consequential damages. So as a contractor, you're going to want a provision in your contract that has a mutual waiver of consequential damages, because an owner typically is the one that's going to have consequential damages. And what they're in the form of like lost profits, lost earning capacity or whatever, not associated with that specific project. The owner could say, listen, because you didn't finish the project on time, I missed out on lost profits or lost opportunity on another job because I was tied up with you. Those are consequential damages. Usually general contractors and contractors, they don't really suffer consequential damages as much as direct damages associated with the project. They're kind of, consequential damages they're kind of funny. They're kind of hard to define, but any other questions? Okay, yeah.
On the flow through,
Oh yeah.
the indemnity clause, it's in the contract that flows through. Same rules apply?
Prime contract?
Uh-huh.
Yes.
Okay.
Yes.
Now, what happens if you have a flow through that is written in another state?
That's good. That's a good question. So, yeah, what if you have a contract that adopts the laws of another state? So that's one of the most important things you want to look for in a contract is what law applies. And you may assume that the Utah law applies because it's in Utah, and typically it does, but a lot of times you might be dealing with an out-of-state contractor that has a provision in there saying, even though the project's in Utah, that California's laws applied. So that is valid. If a contract has a provision that states that another state's laws will apply, then those laws will apply. Does that mean that the lawsuit will be filed in California or whatever state the laws? No. The lawsuit will be filed here, but the judge will be asked to interpret California law, whatever law the contract says. Okay? Does that make sense? So it's very important to understand which laws apply, because while most laws uniform throughout the states, but there are differences in states over laws and lien laws and stuff like that, contract laws. There are some subtle differences. And if you are asked to sign a contract and Utah law doesn't apply, and you feel uncomfortable with provision and whether that's enforceable, like an indemnity, because maybe the indemnity provision is enforceable in another state, I think most states would not recognize it. It's the general, yeah, here we go again. But you never know. Each state is different sometimes. So, any other questions? Okay, before you go, I'm supposed to give you this quiz. Let's go through it real quick. It's contracts quiz. There you go. Let's just run through it, and then we'll get you out of here. Okay. Welcome. Oh, let me take one of those just in case I don't have one.
This is the same one you just went through earlier. Is it supposed to be different?
Mine's different. Is that? Yeah, that's. Did you all get the lien?
No.
Contract. Who got liens? Maybe. Hold on. Are there any extras?
Yeah, we got some here.
Send the extras back. Back down, and we'll see if we got enough for everybody. Do you guys all have contracts? Thank you. Need one? Okay. Does anybody else need one? Okay. Okay, number one, construction contracts must be in writing to be legally enforceable. True or false? It's false. But recommended you have written contracts. Even if it's on like a cocktail napkin. A written contract is valid only if signed by both parties to the contract. False. Contingent payment clauses such as paid when paid and paid if paid are enforceable under Utah law. Yeah, that's technically false. That's false. That's false because we don't know yet. What we think is when it says Utah law, there's no statute that says they're enforceable, and there's no upper court decision. So when what Utah law means is there has to be a reported decision by the Utah Supreme Court or Utah Court of Appeals upholding these provisions. That has not been challenged yet. It's only been challenged on lower levels of courts with trial court judges. They can interpret the law, but that doesn't make it Utah law officially. It means it's trending in that direction, and if a case ever goes up, we think it will be. But as of now, it's actually false. But if you see those clauses in your contract, be aware. Retainage is limited to what percentage under Utah law? Contractors are entitled to interest that accrues on retainage. True or false? True. So next time ask for that interest. They might not know what you're talking about, but you can educate them. Utah law requires a 1-year warranty for construction. True or false? That's false.
Everybody thinks it is, but it's not.
Hold on. I'm confused too. I thought at first it was required, but then I corrected it. There we go. The norm. So yeah, there was a case. The reason why I was confused is there was a construction law case a few years ago where they were trying to claim there's a 1-year warranty. And I think the courts found that there's no Utah law requiring it, but that's normal and customary is typically 1 year. So, yeah, that's false. Number 7, the prevailing party in a construction dispute is entitled to be paid its attorney's fees. If it's in the contract. Yeah. So it's a kind of a depends. Yeah. Yeah, that could be true or false depending on what's in the contract. What is the maximum amount of interest allowed to be charged on past due invoices in a construction contract? There's basically no limit. I mean, courts will probably cut it off at 36, but there's no like law that says 36 is the most. Okay, what are liquidated damages? A, B, C, or D? That's right. B, the amount of damages agreed upon at the formation of a contract. Number 10, changes to a scope of work must always be agreed to in writing. True or false? That's right, false. But recommended that you do it, especially if your contract says it. 11, an interest and attorney fee provision shown on an invoice but not in the contract is enforceable. False. Number 12, what is the best way to avoid and resolve disputes in the construction industry? I think it's I think all of them except for C is kind of a joke, but all of them, having no, you don't have to have a robust contract. I mean, you want a contract that spells out, terms and conditions, important ones. That doesn't mean you have to have a 30-page contract. You can have a contract that's 2 or 3 pages long that gets you what you need. Ensuring that you take all necessary steps to preserve your lien right, yeah. I'd say D is the best answer. So, yeah, communication. I mean, that's the best way. These are all ways you can resolve them, but the best way is communication. All right. That's a long day for you guys. Thanks for your attention.